May I please? Item number 52, Your Lordship. I have taken the consent of the other side. The matter may pass over because I have to file objection, Your Lordship. So that petition filed under Section 5 of the Limitation Act. 52, Your Lordship.
It's a petition for condonation.
We have to respond.
Petition for condonation of the
Condonation. Objection has to be filed.
No. So you are for the
I am for the respondent.
I am for the petition.
respondent number 2.
I am for the petitioner.
I am for the respondent. He is for the respondent.
And then it looks like his name is not reflected in fact that's why it comes. Item number 52. For it. How many books you need?
2 weeks after vacation. Your Lordship.
After.
Yeah. Date may be fixed.
Lakshmi, kindly give us a quick date.
26.
6, 7.
Obviously.
May I please, Your Lordship? I beg to mention item number 76 of today's list, Your Lordship. This is it is shown in the admission column, Your Lordship. But, Your Lordship, it should have come up as a motion matter, Your Lordship. If Your Lordship can take it up after completion of the motion matters, Your Lordship. Notice has not yet been issued, Your Lordship. Yesterday it came before the court number 14, Your Lordship, but since the court is not taking up through VC, Your Lordship, therefore matter is listed before this honorable court. CBI counsel will be appearing through VC, Your Lordship. It should have come up as a motion matter, Your Lordship. If Your Lordship can take it up immediately after completion of the main motion matters, Your Lordship. That's my place.
Mr. Halloway.
Yes, that's why he is, Your Lordship, through VC he is appearing. He is appearing through VC. Lordship. Deeply obliged.
I mean, I have the urgency to fix the date on 26th of this month.
No, which matter you are looking up?
It's a criminal one. Revision.
For listing.
Yeah, for listing. On 26th.
Listing. Now. So,
I have some urgency. Yeah.
revision petition or appeal?
Revision petition.
Revision petition. We mentioned before senior bench. Court number 20.
May I please?
Please, Your Lordship, an urgent bail application we have filed on Wednesday. Can it be on 24 or 25?
So item number 64, I appear for the respondent number 2. Because my learned friend appears for the petitioner. So can it be after the vacation?
Item number 64.
64. Both the parties agree, Lordship. Let it be after vacation.
So you are for the petition.
I am for the respondent number 2.
I am for the petitioner.
You are
He is for the
after vacation.
after vacation.
Well, there is an interim order. Interim order may be continued.
So what do you want to fix it?
Any date, Lordship, subject to your Lordship's
Do you want to
continuing.
date fix it or
Let it be after the vacation, Lordship. Obliged.
Obliged.
May it please, Your Lordship. Lordship, may I pray for upgrading item 11 as Your Lordship will take up the bail hearing matters first, Lordship. Item 11 is admission matter, Lordship. If it not reaches, then can it be taken up at 3 o'clock, Lordship? Already 4 days it remains just left over, Lordship.
if bail hearing after bail hearing it reaches, then to take. Otherwise, at 3.
Lordship, deeply upset.
May I please, Lordship? My Lord, I am praying for listing a bail application on Monday, Lordship, for motion. For motion, Lordship. Bail
Monday,
application.
most probably list is already out. On Tuesday,
Tuesday, Lordship. And Lordship, one more mention, Lordship. Item number 40,
48.
48. I have got information 48. A CD may not be here, Lordship. I have got information. I am in
48. CD not. You are on interim.
Lordship. Interim may be continued.
26-7.
Interim may be continued. Madam.
Yes, we are.
Obliged, Lordship.
May I please, Your Lordship, pray for listing of bail application Tuesday, my lord, for motion,
I don't know. 20,
or Wednesday, my lord,
78, 79 numbers.
or Wednesday, my lord,
May reach, may not reach. I don't know.
Wednesday, my lord.
Okay.
Obliged.
My lord, these three petitions, my lord, record is received, my lord. Kindly listing for next week, my lord. Any date
For
for bail application, my lord. Bail hearing matter.
petition is received
My LCR is received, my lord.
for bail hearing.
Bail hearing matter. Two bail hearing and one criminal petition.
Also.
Witness.
On Wednesday.
Obliged.
May I please, Your Lordship, I beg to mention item number 21. 21 CD is not available, so matter will be fixed on 28, Lordship, this month.
21.
Yes, Lordship.
Yes, Mr. Kusam. No, 21 CD is not there. 20 of
This month. This month. 66 days beyond the hour.
we are listing it on 28.
Yes, Lordship. This month.
May I please, Lordship, I beg to
Then you issue reminder, try to get the CD by 20.
May I please, Lordship, I beg to listing of a bail application, Your Honor. Bail hearing matters, POXO matter, Your Honor, already 50 days passed, Your Honor. LCI will call for order was
I
passed
don't know,
list
yes,
after
and
2
it
weeks,
will
Your Honor. Today 2 weeks completed, Your Honor.
Huh?
List after 2 weeks, last order, today 2 weeks completed, Your Honor. So I mentioned to next day, any day on next day, Your Honor.
Next week means this next day, any day means what? Monday already out, Tuesday is full of very.
There is urgency, Your Honor, already behind about 50 days, Your Honor, government service.
But is
Lordship, motion matter listing on Tuesday, madam. Motion bail petition, madam. On Tuesday, madam. On 19th, I have filed, madam. Obliged.
May I please, Your Lordship? May I please, Your Lordship? Lordship, I beg to mention item 13, Lordship.
1-3.
Yes, Lordship. I am appearing respondent number 2, Lordship.
Yeah.
Lordship, we need to file affidavit, Lordship, and the certificate copy is not yet ready, Lordship. So, Lordship, kindly fix the matter on August.
Have you informed the other side?
Yes,
Lordship,
Lordship.
I am for the other side,
Yes, Lordship.
but I may pray that interim order may be passed, Lordship. If they want the item to be mentioned today, interim may be passed, Lordship. Stay proceedings may be stayed at the door.
Lordship, the next date of lower court is 1910, Lordship. Any date before 1910, Lordship? The lower court date is 1910 on
1910.
for appearance. Yes, Lordship. 19 October. Yes, Lordship. Yes, Lordship. 12 August.
19 October, I don't know, I have not done the record, but this is 19 October, suppose. Then definitely it will take time.
Yes, Lordship.
No, there cannot be any order and all between
Yes.
other witches. So let it be after petition, right?
Lordship, then a date may be fixed.
Lordship, if it's possible, Lordship, 12 August. If it's possible, Lordship, 12 August.
12 of
August, yes, Lordship.
okay, 12 of August.
I am obliged. Lordship.
Not
file-
12, not 12, not 12. Slightly before that, Lordship. Senior may not be available.
8 of August.
8.
Possibly.
May I please, Lordship? May I please, Lordship?
8 of August.
May I please, Lordship? I beg to mention item number 14, Lordship.
1-4.
1-4, Lordship. And it fixed at 2 p.m. Lordship. Lordship. On difficult days, Lordship. Lordship, Mr. A.Z. Ahmed is not available, Lordship. He will come, Lordship.
At 2 you
At
want?
2 p.m. Lordship.
May it please, Your Lordship. My lord, I beg to mention one criminal appeal pertains to PC Act, my lord.
think I mentioned before the senior bench, court number 21. It may reach before the court, but may mention me with that.
May I please, Your Lordship? Lordship, I beg to mention item number 22 and 23, Lordship. Lordship, my senior Mr. M. Khan is out of station. Therefore, matter may kindly be fixed on 27/6.
No, it's not possible.
Lordship, any day before vacation.
Not possible now. It's today we have not have it. We don't have it. It has to be after vacation. What it is? I think it is a chartered one.
Lordship, no, this is not solicited one.
It is available for both. From same. Then what? Sir.
Even if it's on agreement, but it goes there again.
7?
22, 23.
27.
I'm the respondent on the item number 22 and 23.
Oh, watch it.
And I have filed an wakalatnama today only. Yesterday I mentioned item number 70, which has been listed as 77. So they have arisen from the same cause of action. It is 77, yes, ma'am. So that could be here.
77. What to think on the, because it is CD is there, that's why we are taking.
But this is also series there.
Otherwise,
series there. 77.
Oh, it's also AP.
Yes, madam.
Oh, it is 77 is out of same.
Yes.
Okay. Okay.
77.
May please, Your Lordship.
77. So it will be on 27.
May please, Your Lordship. Lordship, with regard to item number 67, Lordship, LCR was called for. LCR has not been received yet.
7.
Stay matters, ma'am.
Yes, Mr.
Let's can go after vacation.
After vacation, interim order may be continued.
Item number 62, minor consent of the other side. We have prayed that the matter will be taken up after the vacation matter.
So you are for the petition?
I am for the petition. I have taken the consent of the private respondent also and the learned public. He appears for the.
Well, I am for the private respondent number 2.
I am for the private respondent number 2.
Yes.
After vacation, you want that?
He. It's
immediately after vacation.
Immediately after. It's immediately after. And was there any?
No, there's a stay order operating. It is not required to be accepted.
Not required to be
No,
already up to
yes. Okay.
Immediately after.
Hello.
May I please, Your Lordship? Lordship, beg to mention item number 27 to 45.
Yes, all these are connected matter, no?
Lordship, we are not pressing this matter.
They are not pressing matter. All were, I think all are AP.
AP,
Yes,
there were no cases but that is why some instructions were called for.
Oh,
Yes, not, but in some of the cases they received no case. Even to enjoy, madam.
should I reflect this? There's no case? No, nothing. It's already withdrawn. In all the matters, Mr.
Yes,
A.M.
all cases.
Mia is there.
Same.
So you are Miss?
Lordship.
You want me?
S.R. Majar Bhuya.
S?
R. Majar Bhuya. S.R. Majar Bhuya, Lordship.
Second name. 1927.
What? S.R.
Apply. May it please your Lordship. I beg to mention item number 56. Item number 56.
Again?
Kindly adjourn the matter for a week.
Why is there a
My senior is not well, Lord.
not well? Who is the senior?
H. Burwa.
Not well. It will be obviously not after 1 week, it will come after vacation.
After vacation.
Is there any interest now?
No.
In respect of item number 8, my lord, my learned friend is appearing on behalf of respondent 2 to 4. In this case, my lord, the LCR will be required, my lord. The LCR, as the cost list doesn't indicate the receipt of LCR. So I may pray, my lord, this matter may be taken up after vacation, my lord. And LCR may be called. I am for petitioner, my lord.
I am for
respondent number 2 to 4.
And you are for?
Respondent number 2 to 4. Any day after vacation also.
At the end of July, my lord, any date on end of July, my lord.
So, as per your information, LCA is
Not, it has not been received, my lord. Cost list doesn't indicate receipt of LCR, my lord.
P dole lo.
From the student by that's not state. So it was for by after beginning.
Yes, my lord. End of July, my lord. Any date in the end of July.
30.
Much obliged. Obliged.
May I please your Lordship? Charge sheeted matter, Lordship, LCR will be called for, Lordship. Commercial quantity. LCR, commercial quantity.
Cancel. Obviously, it should be after beginning.
No, definitely, Lordship.
And it is after. So, is it a bail matter?
Lordship, much obliged. Much obliged, Your Lord. Much.
May please your Lordship. Similar prayer, my lord.
This is also your
Yes, my lord.
LPS matter?
Commercial, yes, my lord. মানে ক'ব নোৱাৰো মানে কোৱা নাই মানুহটো সেইকাৰণে খুচি
It is not.
No, I have no idea, my lord. And
So we have to call for the CD. Then if any instruction comes, we will personally call for.
Otherwise, you don't have any instruction.
No, my lord.
Instructed is not.
After vacation, we will calling for the CD.
CD, my lord, along with এতিয়াহে গম পাম ইমানজনেও নাজানে কাকতটো
Date 29.
The commercial one, 29/7.
Look.
It's when he is in custody. Your
My lord,
person.
custody kitchen.
He was arrested on 16/11/2023.
11.
Yes, my lord.
My lord, perhaps it will be seated, my lord.
Maybe, my lord.
Otherwise, he could.
because 7 months has gone.
So then we are calling for a scanned copy of LCR.
That is also not clear whether we cannot say because
There is no any mention in the
No, my
any
lord,
mention
no.
in the
Because I have no idea, my lord. And
Then what?
let it be for CD if that's otherwise because
along with
otherwise
channel, along with TV.
No, I do one thing.
Yes.
Because otherwise, you see, probably it's the case of charge.
Lost.
Yes, my lord.
So let us call for the scanned copy of the case record along with the case diary.
Yes.
Lost.
It will
that will better.
Better.
Yes.
29.
20.
Obliged.
May it please your lordship. My lord, section 8 POCSO, my lord. Two petitioners, my lord. 28 days in custody.
It is right.
My lord. Probably notice will have to be served upon the
Notice number 2 is there.
yes.
Yes.
Two officer in charge, my lord. Police.
Yes. It will be routed to your office.
Lordship.
My lord, actually, my lord, 28 days, 60 days is the mandatory period. So even if a date is fixed immediately after vacation, it will be around 50 odd days, my lord. So,
Not take them.
if it is fixed even on 16, my lord, it will be around 53 or 54 days. So, my lord, then
Then it is
Next week, most probably, if possible, so immediately on 15 or 16. We'll see. Or
No.
have you approached the current court below?
yes, rejected, my lord. My lord.
Have any outlet have
So immediately after vacation, then?
immediately after vacation on 16
Not-
or 15, don't keep it at 15 because
15
it is
it
there.
is
16
Oh yes, 16 mile.
because CD may reach from 16.
Highly obliged.
पठाई दिवा हमारा पठाई दिवा
Ma'am, please, your lordship. In this case, lordship, co-accused bail petitions are fixed on 28 lordship. CD has already come yesterday listed lordship, pending for injury report lordship. Yesterday it was listed as item 20 and 21 lordship.
28. We then we fix it on
There are
27.
28 lordship along with BA 1639 2024.
They were along with PA.
1639. 39 1640. Two matters. Sir.
Two matters. One is 16.
1639 and another is 1640. Both are fixed on 28.
They fixed it on 28 6.
Lordship.
28
28 6. Lordship. It will come for bail hearing, Lordship. Otherwise, sometimes it comes in motion again.
If it comes on the motion, we can also will dispose it.
Lordship. Much obliged, your Lordship. Much obliged.
My lord, this matter will be taken after some time, my lord. My senior will appear in this case. He is on legs and other good. Obliged.
Please, your lord. Diary may be called for, my lord. Second bail, my lord. That's it.
Short and simple.
If possible, my lord, on 16th. If possible. Hariba. I am obliged.
Instruction in
Yes, ma'am.
as to whether the case
Yes.
has been, whether it has reflected the kind of instruction.
It's not reflected, madam.
So now they 6 years
Yes.
with an apprehension that any case may
Yes,
be
yes,
registered.
madam.
In dispute.
This
Can it be set up? Take
but nobody appears.
nobody appears. Otherwise you have not received
No,
instruction.
madam, not.
Correct. We are listing it on 77.
May I please Lordship? The application 438 application Lordship. FI is page number 11 type copy Lordship. My vehicle is captured by the Sonapur police Lordship when cattle is carrying by driver Lordship. But my name is not in the FIR Lordship.
You are the owner.
Lordship, I am owner.
owner.
I am owner of vehicle Lordship. Page number 60 is the agreement. Main owner is different, but I bring got from the Nur Alam Lordship. Registration certificate is page number 19 Lordship.
Vehicle is not yet registered in your name.
Lordship, I have just bought the vehicle Lordship. This page number 16 is the agreement Lordship.
Just call it and call.
Yes, may call for the CD, madam.
Intermediate protection may be given, Lordship. Simma petition was filed before the CGM, so my appearance is necessary to clarify the vehicle Lordship before the IO Lordship. RL Sutia Lordship. RL Sutia.
He is my.
You are Ritu Moni.
Ritu Moni is Hussain.
It's the
Look.
cancer interim protection.
Look.
But
Passport.
what?
Lordship, can it 28 Lordship? 28.
there before the IO and there will be some direction comply with.
There is an application under section 482 for quashing of the complaint. The present petitioner, my lord, number 1 is the, my lord, Government of India company. 2 is the, my lord, central government employee, my lord. And 3 is the secretary to the Donier Department, Government of India. And 4 is the, my lord, the government servant of the Government of Andhra Pradesh. These 3, my lord, on deputation had served, my lord, in the NHIDCL, my lord. And the respondent number 1, 2, and 3, my lord, they are the complainant. 1 and 2 are the, my lord, partners of the respondent number 3. The NHIDCL had, my lord, awarded a contract to, my lord, the accused number 6 to, my lord, 12, my lord, for construction of a road project, my lord. And what it appears, the accused are the suppliers of certain materials to the contractor and the subcontractor. They are claiming certain amount of money. Some amount has been paid, some have not been paid. That is the basic, my lord, the contention in the entire complaint. To that extent, my lord, they had also, my lord, had issued a notice under section, my lord, 80 of the CPC, to which the present petitioners have replied to it. But after receipt of the reply, the present complaint has been filed. My first contention is that this is out and out a civil dispute regarding payment of the money by the accused number, my lord, of 6 to 11, and, my lord, the 12 to, my lord, 14, my lord. Secondly, my lord, they being the government servant, my lord, this
14 numbers.
14 numbers. 14 numbers, my lord. Lordship will kindly find the complaint, my lord, is at page 19. This we have been implemented as 1, 2 to 5, 6 to 12, 6 to 11 are the contractors to whom we had awarded the contract. Primarily, my lord, the accused number 6, Ganon Dankarle, and the rest are the officers under the Ganon Dankarle. We had awarded the contract to respondent number 6. And, my lord, subsequently, this Ganon Dankarle has, my lord, subcontracted it to this accused number 12. And 13, 14 are the officers under the respondent number 12, complainant number 12, accused number 12, my lord. The entire recitation, your lordship, few of the paragraphs, if your lordship goes, my lord, page 23, that the accused number 6 to 11 got tender from accused number 1 to 5, and they entered into an agreement with the accused number 1 to 5 for 4 lane of National Highway number 37 from Jhansi to Demo section from kilometer so-and-so in the district of Shivsagar, Assam, so-and-so engineering, procurement and construction mode. After obtaining the contract work order by accused number 6 to 11, negotiated with the complainant at Dibrugarh, Assam to supply various construction material of roads to them and induced them to supply all those material to them with undertaking that they would pay bill amount of the supplied materials on furnishing its respective bills, and entire deals and transactions were effected between the parties at Dibrugarh, and bill amount whatsoever were paid by the accused were credited in the bank account of the complainant, being account number so-and-so, Tokudingi branch at Dibrugarh. Then, lordship, may come to paragraph 5. That on 28, 2019, the accused number 6 to 11, that is principal contractor, entrusted the aforesaid contractor to the accused number 12 to 14 to complete the works, and accordingly the accused number 12 to 14 started execution of the aforesaid work with the raw materials aggregating boulder, stone and other materials supplied by the complainant as per their requirement, and submitted its bill to them against the supply materials to the accused number 12 to 14 for its payment as requested by the accused number 6 to 11 as well as accused number 12 to 14. It is stated that accused number 11 to 1 to 11 stood as guarantor against payment of the bill amount for the accused number 12 to 14 and undertook that they would not grab the bill amount by committing fraud. These are the bills they have given. Then, my lord, will come to page 29, paragraph 7. That the complainant supplied the materials to the accused person to satisfy their requirement worth rupees 3 crore 78 lakhs 12,930.95 to GDCL and rupees 1 crore 96 lakhs 38,352.22 VSD Infra Limited, that is accused number 12 to 14, totaling to rupees 5 crore 7451 283.7. These are the total works done by them. And certain amounts they have paid and some amounts they have not paid. Then your lordship may come to paragraph 9 at page 31. That on 13/9/2000 the accused number 12 to 14 gave written declaration to the complainants that they would pay the bill amount in two installments of rupees 50 lakhs on 15/9/2021 and 38 lakhs 73,810 on 25/10/2021. But they neither paid amount nor shown any interest for payment of the same, and as such matter was informed to the accused number 1 to 11. Then lordship may skip the others, my lord, directly come to the, my lord, cause of action, my lord. They have mentioned at paragraph at page 35, paragraph 17, that the cause of action has arisen on 1/12/28 when the complainant started supplying materials to GDCL. When the complainant started to supply materials to VSD Infracon on 8/7/21, when the partners of VSD Infracon LLP a check bearing so-and-so to the complainant which was dishonored due to insufficient of fine on 23/10/2021, the partners of VSD Infracon issued two numbers of check bearing so-and-so to the complainant which were dishonored due to insufficient of fund on 13/9/21, when the accused number 12 to 14 issued a declaration on 15/9/2021 and 25/10/2021, when two installments were due but were not paid. Accordingly, on 10/1/2022, when VSD Infracon LLP and GDCL gave a handwritten resolution for making payment of the due amount on 11/1/2022 and 30/1/22, when amount was due for payment but were not paid accordingly. On 7/2/2022, when a meeting was convened at the office of the Deputy Commissioner Sibsagar on 31/3/2022, when the amount was due for payment as resolved in the meeting before Additional Deputy Commissioner Sibsagar but not paid. On 19/5/22, when again a meeting was convened at the office of the Deputy Commissioner Sibsagar on 22/3/2021, when a legal notice was issued to the accused person on 3/5/23, when accused number 1 to 5 replied to the notice, when some distorted version on 20/11/23, when accused person sent two unknown persons to threaten the complainant. These are the cause of action, all arising against the accused number 6 to 14. Now, your lordship will kindly see the legal the notice reply we have submitted, my lord. At page 59. Let's come to paragraph 3. That in reply to paragraph 3 of your notice, it is stated that upon completing bid, Messrs. GDCL was awarded the work of four laning of Jhaji to Demo section of NH 37 from kilometer so and so in the state of Assam under SIRDP-NE on EPC mode by competent authority. Thereafter, contract agreement was signed between NHIDCL and Messrs GDCL on 21/11/2017. This office of my client has not any record regarding placing of supply order to Messrs KD Enterprise, that is complainant, situated at Milan Nagar, so-and-so, and as such, my client does not prefer to comment on the issue as required by you in para 3 of your notice. That in reply to paragraph 4 of your notice, it is stated that the office of my client does not have any record regarding submission of bill by Messrs KD Enterprise to Messrs GDCL, and as such, my client does not prefer to offer any comment. That in reply to paragraph 5 your notice, it is stated that as per available records, VSD Infracon LLP has not been the approved subcontractor of Messrs GDCL EPC contractor of Jhaji Demo section NH 37. The allegation made in paragraph 6 of your notice is not agreed by my client. It is further stated that as per available record, Messrs VSD Infracon has not been approved subcontractor of Messrs GDCL contractor of Jhaji Demo section of NH 37. 7. That in reply to paragraph 7 and 8 of your notice, it is situated that authority has no role with regard to supply of material from any vendor, and hence my client prefers no offer to comment. Basically, we don't have any contract with them. He was the subcontractor or whatever, my lord, he has supplied to the, my lord, the accused number 6. Now the 6 never forwarded any bill of KD to us, nor we have ordered to them, my lord. Now, having received this reply, the complaint has been filed, and they issued this notice under section 80, knowing fully well the persons whom they are going to array are the, my lord, central government and the state government employee. They are just on deputation. Now they have been working in their respective places, except 2, my lord. The court, my lord, on receipt of the complaint, your lordship will find on 3/2/2024 at page 63. They examine as CW1 and CW2 under section 200 and 202 CRPC. My lord, all the petitioners, present petitioners, are residing outside the territorial jurisdiction of the court at Dibrugarh. So, my lord, the examination under section 202 is an imperative. Now, though it has been said, my lord, they are examined as CW1 and CW2 under section 200 and 202, these 2 persons are the complainant, the partners of the firm. Now, for further inquiry under 202 that has been fixed, my lord, the next date on 2/3/24, that your lordship will find the order at page 65. Today was fixed for further inquiry. Complainant are present along with the engaged counsel, heard the learned counsel for the complainant, perused the case record and gone through the statement recorded under section 200 and 202 CRPC and relooked the complaint petition. I find prima facie material against all the named accused person in the complaint petition under section 406, 420 and 506 of IPC. Accordingly, issue summons to the accused persons. This order is under challenge. On the first ground, they being the government servant, the prosecution sanction is the imperative before taking cognizance by the court, number 1. Secondly, all the persons are being resident outside the territorial jurisdiction. Examination under section 202 is imperative, and which means that all the witnesses or some of the witnesses are examined. Here, none of they have been engaged. And thirdly, your lordship will see, my lord, the prima facie material against all the name accused persons. My lord, cognizance is taken against the offence, not against the persons. But here the cognizance has been taken against the accused persons. So these are the ground on which I am assailing. All the persons are the government servant as well as coming to Dibrugarh as an harassment, and they have opted for that after the receipt of the reply under section 80 of the CPC. And in fact, on the similar, some of the other the suppliers, they had also filed a similar ditto complaint before the court, which was registered as case number 132. Present one is registered as 131. And this court, my lord, having found that there is no the ground, my lord, for satisfaction under section 406, 420 and 506, the proceeding has been stayed in that case. I am praying for a similar order.
KJ Secure. KJ Secure.
Pass by that. The
EPC contractor. 6 to 11 are the contractors. Are the suppliers to the contractor, suppliers of material to the contractor.
when it was got.
My lord? Lordship.
Before filing of the complaint.
Filing of the complaint. That was page 50, my lord. Lordship. They have mentioned in page 53, subject notice under section 80 CPC.
are and so don't but but water pump or it or but one five not five
5 minutes.
five
1 to 5.
one five
Some minor correction perhaps may be required. Melody. Petitioner number 1 is the Government of India company. Company. And 3, 4 are the central government employee. 5 is the state government employee. God bless.
up or admission not motion.
Lordship, can this matter kindly be taken up at 2 o'clock?
Otherwise, it was in the
Admission
column,
from
but
your lordship.
as the Mr. Portable in the morning of submitted that should be
In the motion column, your
motion
lordship,
column.
because there has not been any notice issued, your lordship. This is-
Yes. So, it was Mr. Halloway, who was supposed to be the to receive,
Yes,
now
your
he
lordship.
refused because of most of the
Okay.
some reason. So, he doesn't want here to be also. So, one thing, otherwise, notice is not it.
No, your lordship.
We'll pass an order for event or not. Otherwise,
Your lordship, there is an interim direction or observation from this honorable court we require, your lordship, to apply for passport. So that is why if your lordship kindly takes it up at 2, we'll inform
you
Mr.
can
Halloway also.
hear Mr. Halloway. In that case, if we give them, prayer for any passport application,
Okay.
in that case, we have to hear, without hearing him, I think. So in that case, he's praying our government to demonstrate it because of.
Note.
So, if such kind of order is required, then either it may be 50 application. I think.
Okay, can it be on Monday then, your lordship?
Okay, Monday.
Because his passport actually expires on 25th of July, your lordship. So he has to apply a month before that. So that is 25th of June.
On Monday, just require the which instructor. Then only. Okay, we'll make an inquiry with Mr. Halloway. If it is possible on part to receive it,
Lord.
then we'll make it on part.
Lord.
Just after some time, we just make an
Lordship. Much obliged.
One, 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 one. Right. Okay.
May it please the Lordship. My Lord, I will take your Lordships to page 17, my Lord, which is the
Who is
FIR.
Borba, you are a bit. Please.
Page 17, this is the FIR, my Lord. Lordship got it.
Here.
With reference to the subject cited above, I have the honor to inform you that the information was received. This is important, my Lord. Information was received from so-and-so Karimganj, APS by me at 8:30 p.m. That is after sunset. Yesterday, that is on 1/9/2022. As per the information, a large quantity of suspected to be narcotic drugs is being transporting from Karimganj to Badarpur area via so-and-so in one number of Bolero car bearing registration number so-and-so, and a team of Karimganj police being led by him was chasing the vehicle and asked me to fix a check post immediately for detention of the vehicle. Accordingly, GD entry was made by me, by GD entry number so-and-so. There was urgency for conducting detention and search as the consignment of narcotic drugs was likely to be transported to some unknown places in no time, as the authorization from a gazetted officer as per Section 42 of the NDPS Act could not be obtained for conducting detention and search after sunset, as it was believed that such authorization could not have been obtained without affording opportunity for concealment of evidence, facility of escape of offenders, and removal and transportation of NDPS substances. Ground of such belief was recorded by so-and-so, so-and-so. Now, I, along with the aforesaid police party, arrived at Bhanga Bazar by our government vehicle, bearing registration number so-and-so. At the very moment, we put barricades to block the route and detain the vehicle in the Naka post at Bhanga Bazar. Before starting the search, we have called two independent witnesses of the locality. Now, these are the witness number 1 and 2. It is to mention here that the police team from Karimganj, led by Githartha Dev Sharma, APS, Karimganj, and then Bhavin Dhingia, OC Badarpur Inspection, Chandan Goswami also arrived at the spot in the meantime with their staff. We identified ourselves and also offered ourselves to be searched by the independent witnesses before starting the search of the Bolero vehicle bearing registration number so-and-so and two suspected persons, namely Ahmedur Rahman Barbhuia. We are concerned now with Mr. Ahmedur Rahman Barbhuia. Number 2, Kaji Alauddin. On being asked about the narcotic drugs, the suspect stated that the drugs concealed under the driver's seat of the vehicle, hence there was no requirement of searching their body and no notice under Section 50 of NDPS Act issued to them. I then started the search of the vehicle in presence of the above mentioned witnesses while complying with the provision of Section 42 of the NDPS Act. The following items have been recovered by me from the possession of the suspected person, concealed in the vehicle as well as produced by them. 10 numbers of soap boxes containing suspended heroin. Weight of soap boxes at box number so-and-so, so-and-so. Now there are some boxes. Now the weight of suspected brown sugar without boxes 131 gram. This is, my lord, below the commercial quantity. Now, number 2, one blue carry bag used to pack the 10 numbers of soap boxes containing suspected heroin. Now, your lordship, kindly mark blue carry bag. This has its bearing, my lord. Now, number 3, this is very important and very vital issue to be decided in this case, my lord. 3 numbers of black packets containing suspected Uva tablets, orange, red color. These two also Your Lordship kindly mark it, orange and red color. Each packet containing approximately 200 number of tablets and total 200 into 3, 600. Now Your Lordship kindly see the weight is 66 gram and this is 3 packets. This is important. I will take Your Lordship how sampling was done. And my lord, the law is very clear. My lord, even sampling is defective, but it violates my lord, standing order and all that, which is statutory in nature. Now, my lord, it's not a question of that it will have to be gone into merit. Even in the stage of bail also, if there is violation, my lord, it's in case of acquittal and the rigor of 37 will obviously not come. In that context, I will take Your Lordship to certain decision of the appeals court also. Then, my lord, 4 and 5, Your Lordship may skip. The name of the accused, Your Lordship kindly see. Number 1, Ahmedur Rahman Barhuya. He is the petitioner here. The number 2 is Kaji Alauddin. Then Your Lordship may come to page 19, the forwarding report, that is ground of arrest. Your Lordship will find what is the ground of arrest. At page 19, my lord, in the middle part, Your Lordship will find that. Date and time of arrest, then ground of arrest. The accused persons, if not arrested, would have hampered the investigation. They have political power and they are aggressive in nature, so they may threaten the prosecution witnesses. Number 2, the accused persons may commit further same kind of offense if not arrested. Number 2, ascertain their presence in the court, their arrest is necessary. The accused persons may abscond somewhere impeding the investigation process of the case. Since the accused persons have been arrested, the ground of arrest has been communicated to the accused persons by serving notice. Now these are all stereotype things that always Your Lordship will find. Now Your Lordship may come at page 21, which is the seizure list. Your Lordship has already seen 1, 2, 3, 4. These have been seized by the authority. And then, my lord, the last part, method of sealing, Your Lordship, kindly have a look. The seized in 2 numbers big yellow envelope and sealed using ₹5 coins and signature of accused witness and seizure officer taken on. Now, this is how they have seized. Then the charge sheet, Your Lordship will find at page 23. Your Lordship may skip this. Your Lordship may look at page 30, my lord. 30, sampling. How they have, the sampling was done. Page 30, it starts the description of articles. One sealed envelope marked as Exhibit A, having a closed polythene packet containing 5 gram light brown colored powder, substances marked herein as DN so and so. Number 2, one sealed envelope marked as Exhibit D, having a closed polythene packet containing 50 numbers of loose, small pink colored. You'll also kindly mark it, pink colored now here. Now, earlier your Lordship has seen when it was seized, it was, my lord, just 1 minute. Orange and red. Now, at the time of sampling, my lord, loose, small pink color. Then your Lordship kindly come at, my lord, the middle part. The following items have been recovered by me from the possession of the suspected person, concealed in the vehicle as well as produced by them. 1, 2, 3, 4 and 5, your Lordship has seen that earlier. Now I am taking to your Lordship number 3. 3 numbers of black packets containing suspected Uva tablets, orange, red color. Each packet containing approximately 200 numbers of tablets and total tablets 200 into 3, 600 and gross weight 66 grams. Now, the sampling, your lordship kindly see, if there is a 3 packets, then my lord, the prosecution will have to show from all the 3 packets, my lord, they have taken the sampling. That is, your lordship will find there is standing order. Your lordship kindly turn to page 2. Down below, my lord, standing order 1.89. Lordship got it. While the central government considers it necessary and expedient to determine the manner in which the narcotic drugs and psychotropic substances as specified in notification number so and so, which shall as soon as may be after their seizure be disposed of, then the next para, now therefore, in exercise of the powers conferred by subsection 1 of section 52A of the Narcotic Drugs and Psychotropic Substances Act 1985, the central government hereby determines that the drug specified in the aforesaid notification shall be disposed of in the following manner. Now, why I had shown this, my lord? It was these standing orders is having a statutory flavor since it was enacted in view of, my lord, exercising the power conferred by subsection 1 of section 52A. Therefore, it is having statutory flavor, statutory force and all that. Now, your lordship turn to the next page. General procedure for sampling, section 2, your lordship can listen. My lord, your lordship mark 2.4 and 2.5. In the case of seizure of a single package container, one sample in duplicate shall be drawn. Normally, it is advisable to draw one sample in duplicate from each package container in case of seizure of more than one packet container. 2.5. However, when the packages containers seized together are of identical size and weight, bearing identical markings, and the contents of each package given identical results on color test by the drug identification kit, conclusively indicating that the packages are identical in all respects, the packages containers may be carefully bunched in lots of 10 packages containers, except in the case of ganja and hashish charas, where it may be bunched in lots of 40 such packages containers. For each such lot of packages containers, one sample in duplicate may be drawn. Now here, my lord, there are 3 packets, and it was incumbent on the prosecution. They will have to take the sample from 3 of the packets. Now it is not known, it is their burden, my lord. They will have to show from the record whether the sampling was done in accordance with the standing order. If it is not done, my lord, it's a violation. And if it's a violation, it's a case of, my lord, acquittal. And if it's a case of acquittal, even at the stage of consideration of the bail, my lord, rigor of 37 will not come, and your lordship may grant the. My lord, in order to, my lord, persuade your lordships, my lord, I will take your lordship to a decision of the Patna High Court, my lord, highlighting the system of sampling, my lord. Is it Allahabad? Allahabad. Well, it's from Allahabad High Court, state of UP. I'll read, my lord, paragraph 3. Learned Senior Counsel on behalf of the applicant submitted that Sub-Inspector lodged a fast information report on so and so against the applicant and 2 others with the allegation that on the basis of information received, fast information No, it's all right. Can I start?
Yes.
Paragraph 3, my lord, I am reading once again. So-and-so for the applicant submitted that sub-inspector lodged a first information report on 17/11/2019 against the applicant and two others with the allegation that on the basis of information received after informant seized a truck on 17/11/2019 at so-and-so, which was alleged to be driven by applicant and carrying 91 packets of ganja weighing about 201 kg. He further submitted that 91 packets of alleged contraband in 8 bags was alleged to be recovered from inside the truck, but only one packet weighing 1 kg out of 91 packets was sent for chemical examination. So at most 1 kg can be said to be ganja, but remaining 200 kg cannot be said to be ganja or any other contraband unless there is a proper sampling and its chemical examination. He further submitted that it is not mentioned in the recovery memo that from each 91 packets, sample of alleged contraband was taken and sent for chemical examination. As such, the procedure of sampling adopted by the police authorities in violation of standing order instruction number so-and-so, it is so-and-so. He has placed reliance upon clauses just I have read, Your Lordship. Your Lordship will keep all this. Then Your Lordship may come to paragraph 4, my lord. He next submitted that there is no evidence on record regarding taking of samples as provided in standing order instructions mentioned above. As such, taking of proper sampling is highly doubtful. On the point of sampling of contraband, learned counsel placed reliance upon following judgments. So these are the judgments relied in order to show that the standing order is having statutory force. But the Supreme Court, way back in 2008, clarified that. I am not bothering your Lordship with that. Your Lordship may skip that also. Your Lordship may come to paragraph 7, my lord. Page 5. Now the counsel further submitted that if power is given, this point is very important because I will be taking to your Lordship section 42 also. So that will have relevance of this para also. And the counsel further submitted that if power is given under the Act statute rules to do a certain thing in a particular way, the thing must be done in that way or not at all. The other methods are forbidden. Now, the Lordship has referred certain decision on that point. Then paragraph 8, learned counsel further submitted that by the order dated 31/8/2020, this court has directed learned so-and-so to file counter. Accordingly, counter affidavit has been filed in this case, but there is no categorical averment in the counter affidavit that sampling was done according to standing order instruction. He further submitted that these court by order dated so-and-so directed to counsel for a point applicant to inform the court about the status of the trial. Accordingly, supplementary affidavit was filed by the applicant on 13/9/2021 enacting the certified copy of the order sheet in order to demonstrate that the trial has not been concluded and prosecution has not produced any witness in the court. Therefore, custody of the applicant is against the provision of Article 21 of the Constitution of India. He further submitted the trial is still pending. The counsel lastly submitted that applicant has no other criminal antecedent. On the other hand, learned so-and-so submitted that search was made in accordance with law and total 91 packets weighing 201 kg contraband was recovered, from which sample has been taken and sent for chemical examination, in which it was found that sample weighing 1 kg was ganja. He further submitted that investigation was conducted in free and fair manner. Accordingly, charged they have shown that they are the holy cow. Then paragraph 11. In reply, learned counsel for the applicant submitted that the applicant is in custody from more than 2.5 years and The trial is still pending and there is fair chance of acquittal of the applicant on the ground mentioned above. So applicant is entitled to be released on bail. On the point of custody, learned counsel for the applicant placed reliance upon a case arising out of NDPS Act in which point of sampling etc. were involved. And the Appeals Court has released the accused on bail in which accused so-and-so remained in custody for over a period of 2 years. The reference of this case is as follows. Then paragraph 12. The court, while considering the provision of section 37 of the NDPS Act, finds that state was granted time to reply. The state has filed counter affidavit which has been taken into consideration. So far as other condition is concerned, it will be relevant to mention that the Appeals Court in the case of so-and-so has held that court, while considering the bail application with reference to section 37 of the Act, is not called upon to record a finding of not guilty. It is for the limited purpose essentially confined to the question of releasing the accused on bail that the court is called upon to see if there are reasonable grounds for believing that the accused is not guilty and record such satisfaction about the existence of such grounds. It is further material to state that the applicant has no criminal history which is not disputed with the state. Now, this, my lord, I'm sick. Now, your lordship may see 14. Ultimately, this Wali Hassan involved in the Portit case, he released on bail on their furnishing. Now, in this case also, because of, my lord, discrepancy or, my lord, not complying the sampling procedure, my lord, he was ultimately enlarged on bail. My lord, often, my lord, the other side argues, these are the matters will come within the parameters of, my lord, consideration of merit. But in my respectful submission, when we can show that if the prosecution can show the sampling was done in accordance with the standing order, we are out. But, my lord, the moment they fail to do that, my lord, strict adherence of the compliance of the standing order will have to be. This is a mandatory provision. You cannot say this is not a state having no statutory force. Appeals Court has already dealt the matter. So the point on this is res integra. So therefore, my lord, this is one point. I'll come to your lordship on the question of section 42. 42 also, my lord, there is no adherence on that part. Before going to that, I'll take your lordships to once again FIR, my lord, page 17. Lord, the lordship kindly see page 17. Then I will take your lordship to section 42. With reference to the subject cited above, I have the honor to inform you that information was received from so-and-so, so-and-so. Then, this is the first part, my lord, 42.1. This part is validated. Then second part, there was urgency of conducting detention and search as the consignment of narcotic drugs was likely to be transported to some unknown places in no time. And the authorization from a gazetted officer as per section 42 of NDPS Act could not be obtained for conducting detention and search after sunset, as it was believed that such authorization could not have been obtained without affording opportunity for concealment of evidence, facility of escape of offenders, and removal of transportation and NDPS substances. Now, when you come to this, there must be a specific finding in terms of 42. My lord, I'll your lordship kindly see section 42. Power of entry, 42 minutes. Power of entry, search, seizure and arrest without warrant or authorization. Any such officer being an officer superior in rank to a peon, depot or constable of the departments of Central Excise, Narcotics, Customs, Revenue Intelligence or any other departments of the central government, including paramilitary forces or armed forces that is empowered in this behalf by general or special order by the central government or any such officer being an officer superior in rank to a peon, depot or constable of the revenue, drug control, excise, police, any other department of state government, as is empowered in this behalf by general or special order of the state government, if he has reason, your lordship kindly stress on this, if he has reason to believe from personal knowledge or information given by person and taken down in writing that any narcotic drug or so and so. Now this is important, my lord. Now they have a reason to believe that they have information received from DYSP, Deputy SP. Now if you get that information, immediately, my lord, in terms of the statute, you have to write it down in a, my lord, independent register, not in a GD entry method. Now, many of the high courts has explained that. I will take your lordship to that. So here your lordship will find what they have done. In page 17, your lordship will find in para 2, no, in para 1 itself, asked me to fix the check post immediately for detention of the vehicle. Accordingly, GD entry was made by me, white GD entry number so and so. Now, this will not do. My lord, whatever you do, whatever writing you do, that will have, must be not, my lord, it must have a public view. GD entry, my lord, public has no access to that. So therefore, many of the high courts have said, it will have to be in an independent register. You will have to make an entry which should be having the public view for all the time to come. Now the next part, my lord, 42, second proviso I will take. Provided further, second proviso. Provided further, if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, he may enter and search such building, conveyance or enclosed place at any time between sunset and sunrise after recording the grounds of his belief. Now, he will have to record his satisfaction why he has come to that finding. Now, these are the 42 specifically, my lord, they have flouted. My lord, I will take your lordship a decision of Calcutta High Court, which has dealt this subject very specifically, my lord. I will read from paragraph 16 onwards. Paragraph 16. Section 42 of the NDPS Act relates to the power of entry, search, seizure, and arrest without warrant or authorization. Section 42(1) casts a mandate on the designated officer to record his reason to believe with reference to personal knowledge or information received, where on that matter, and to take down in writing that any narcotic, drug or psychotropic substance in respect of which an offence punishable under the Act has been committed is liable for seizure and is kept concealed in building, conveyance or enclosed place. The officer must record the reasons for such belief before entering and searching any such building, conveyance or place between sunrise and sunset. Section 42(2) continues the statutory mandate on the officer who intends to enter and search the building, conveyance or enclosed place between sunrise and sunset to intimate his immediate official superior the information recorded in writing and the ground for his belief under section 42(1) within 72 hours. In the present case, the prosecution has submitted that the alleged secret information received by the prosecution was written down provide a general diary entry by the special task force, which was subsequently intimated to the superior officer. The relevant documents are part of record. And paragraph 19, where however of the view that a mere GD entry does not amount to due compliance of section 42(1), the Bombay High Court in Rajiv Hall versus so-and-so, that an entry taken down in the station diary cannot be treated as information recorded under section 42(1) of the Act. The court relied on such and such to hold that an entry in the station diary is not due compliance of section 42(1) of the NDPS Act. Now, Your Lordship may see para 22 and 23. We also rely on Bhuta Singh Supra to come to the conclusion that non-compliance of section 42 is not permissible in law. We are of the view that the report under section 42(1) must be in terms of a clear recorded statement in writing by the authorized officer under section 42(1) and must not be contained in a document which is closed from public view. Our view is strengthened by the fact that the NDPS Act is a special legislation containing several statutory restrictions against grant of relief. Hence, the obligation cast on the officers must strictly be construed as also the rights available to an accused under the Act, which must also be given their due weightage. So ultimately, my lord, in this case, the bail was allowed. Now, my lord, the question may arise, my lord, the public prosecutor may argue that these are the questions, my lord, to be considered at the time of merit. But the Apex Court has clarified that. Now I will take your lordship to that judgment. Your lordship is already aware of, but just I am once again, my lord. 2004-12 SCC, page 266, paragraph 7, my lord. It is pertinent to note that in the bail application of the appellant, it was alleged that there was serious violation of section 42 of the NDPS Act. In the impugned order, nothing is stated about the alleged violation of section 42, and it is observed that it was not necessary to consider such violation at this stage. The compliance with section 42 is mandatory, and that is a relevant fact which should have engaged the attention of the court while considering the bail application. So if there is a mandatory violation, my lord, your lordship, the stage of consideration of the bail, your lordship can consider it. My lord, I will take your lordship another judgment. Hello, I believe I am not bothering your lordship. I will take some other 15 minutes. My lord, the next decision, my lord, Bombay High Court, the relevant paragraph 5 onwards, my lord. Section 42(1) of the NDPS Act requires the person receiving the information to record it into writing. Section 42 of NDPS Act mandates that such information received by the police station has to be forwarded to the immediate superior of the officer receiving the information within 72 hours. In the case at hand, the police inspector is the officer who had received the information. Therefore, it was obligatory on his part to record the information as mandated by section 42(1) of the NDPS Act and send it to his immediate official superior within a period of 72 hours. So far, the recording of information as required under section 42(1) of the NDPS Act is concerned, Admittedly, the state information was not recorded. It was tried to be argued that the entry was taken in session diary. So, for the recording of information required under Section 42(1) Act is considered, admittedly, the state information was not recorded, and the same is thought to be treated as an information recorded under Section 42(1) of the NDPS Act. Learned Counsel Sri Bhosle please reliance on the case of Rajaram Kadu versus so and so. In the case of Rajaram Kadu cited, this very question had fallen for consideration before this court. It has been held thus, as far as non-compliance of Section 42 of the Act is concerned, it can be seen that the information was received by police Nayak so and so. The FIR does not indicate that he had reduced the information into writing or provided any copy of the information to his superior officer. The statement of so and so also does not indicate that he had reduced the information into writing or forwarded the same to his superior officer. However, the prosecution is relying upon the entries made by senior PI so and so that the compliance of Section 42. That cannot be considered to be the compliance of Section 42. The point which is conversed by learned counsel for applicant is that the person who had received the information had not forwarded it to the superior officer, and there is nothing on record to indicate that any such information was forwarded in writing. It is therefore rightly contended that there is non-compliance of Section 42 of the NDPS Act. These observations of this court clearly indicate that entry in session diary is not compliance under Section 42 of the NDPS Act. Then your Lordship kindly see paragraph 11, paragraph 11b. But if for the information was received when the officer was not in the police station, but while he was on the move, either on patrol duty or otherwise, either by mobile phone or other means, and the information calls for immediate action, and any delay would have resulted in the goods or evidence being removed or destroyed, it would not be feasible or practical to take down in writing the information given to him. In such a situation, he could take action per clauses A to D of Section 42(1), and thereafter, as soon as it is practical, record the information in writing and forthwith inform the same to the official superior. Then paragraph 12. In the case at hand, there is not even a delayed complaint. Simply a letter is forwarded to the official superior about the information received. In this view of the matter, since there is no compliance of Section 42(1) and 2, there is no possibility of conviction of the accused as held in the case of so and so. The question of compliance can be considered at the stage of consideration of application for bail. In this view of the matter, the applicants are entitled to be released on bail. My Lord, the Luftar Rahman and the 2011-8 SCC, they are in the same footing, my Lord. I am not reading it out, my Lord. Now, my next submission would be, my Lord, your Lordship is well aware, it is the burden of the, my Lord, prosecution to establish the element of position of contraband. Now here, the contraband, my Lord, they will have to show that I was in conscious position. It is exclusively, my Lord, their duty. Now the next point, my Lord, the point of incarceration, I will, the recent decision is that 2024 it has come out. The last decision, your Lordship can listen. This person is almost 670 days, my Lord. 657. He was arrested on 2/9/2022. My Lord, I'll read out this decision. It covers my case squarely, so far the point of incarceration is concerned. There is Ankur Chaudhary, 2024. The petitioner is in custody since last more than 2 years in connection with so-and-so, registered at police station Chandannagar. So the offence punishable under section 8 read with section 22, 29 of the Narcotic Drugs and previously, when the petitioner approached this court by order dated 15/5/2023, his bail petition was not entertained. However, in this case also I would like to tell you, Lordship, this is a second bail application. We came earlier. In that court, my Lord, it was these are the new grounds, my Lord, with the point of incarceration on section 42. This was not canvassed earlier. So therefore, my Lord, your Lordship can see to that. Previously, when the petitioner approached this court by order dated so-and-so, his bail petition was not entertained. However, liberty was granted to approach the trial court for bail after the examination of the punch witness. Learned counsel for the petitioner submits as the punch witness. Your Lordship may skip this para. Then learned counsel appearing on behalf of the respondent state submits that in the facts of this case, the investigation officer may be treated as punch witness. Therefore, the High Court has rightly rejected the bail application. Third, learned counsel for the parties, we have considered the facts and all attending circumstances, including the period of custody and also the previous orders, where this court, while rejecting the bail, was of the view that after the punch witness deposed, best reports may be taken. Now, on examination, the punch witnesses have not supported the case of prosecution. On fact, we are not inclined to consider the investigation officer as a punch witness. It is to observe that failure to conclude the trial within a reasonable time, resulting in prolonged incarceration, militates against the precious fundamental right guaranteed under Article 21 of the Constitution, and as such, conditional liberty overriding the statutory embargo created under Section 37 may in such circumstances be considered. In view of the above, we are inclined to allow this petition and direct to enlarge the petitioner. Now, my Lord, my case is also squarely on the same footing. Now, since he has been in the custody for long 657 days, at least, even if your Lordship consider other grounds also, he has a strong case of our section 42 of our standing order. He has a very strong case, my Lord. But above all, my Lord, on this ground also, he is entitled to get treatment. And the Supreme Court, this latest decision also supports. Lord, I conclude.
May it please your Lord. My Lord, admittedly, my Lord, there are two contraband, my Lord. One is, my Lord, Yaba tablet, my Lord, which is 66 grams. That is come to commercial quantity, Lord. That is more than 50 grams. And another is 131 grams, that is brown sugar, my Lord. That is intermediate quantity, my Lord. Now, Lord, the charges committed in this case against both the accused parties, and charges have also been framed, my Lord. And out of 10 prosecution witnesses, 3 witnesses have already been examined, my Lord. They are PW 1, 2 and 3, and they all implicated both the accused persons, my Lord. All the PW 1, 2 and 3, they have implicated. Now, my Lord, as far as the evidence are concerned, as on that, my Lord, because there are 7 witnesses yet to be examined, my Lord, there are materials against the accused persons, my Lord. Now, my Lord, my learned senior friend, my Lord, he is arguing, my Lord, section non-compliance of section 42 and section 52, my Lord. Now, Lord, the third I'll take your Lordship to page 30, my Lord. This is the third sheet, my Lord. The last part of the third sheet, Lordship will directly come to page 30. I am not reading the entire, my Lord, only the reading the important lines, my Lord. That is, my Lord, page 30, my Lord, 16, brief text type of the case, my Lord. I am just reading the, my Lord, middle portion, my Lord. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 line, my Lord. Ground of first belief was recorded. It was a, my Lord, prior information, my Lord. Information was received that, my Lord, a contraband is coming, my Lord. So, my Lord, the ground of first belief was recorded by Molua PICP GDNT number 9 of 9 dated 1/9/2022. Then, I, along with police personnel headed by me, left for Bhanga Bazar on so at 1:35 p.m. by GDNT number so. So they have recorded, my lord, the prior information received, and they have proceeded, reported, my lord, before proceeding to the, my lord, scene of occurrence, my lord, they have written down the information, my lord. Then, my lord, the vehicle was stopped, it was searched, my lord, the contraband was found. Now, my lord, directly come to the last paragraph of the lordship, that is the search, page 30. Page 30, last paragraph, my lord. During the course of investigation, I visited PO, drawn up rough specimens of the PO. These drugs were sampled for FSL examination in presence of magistrate. I also, my lord, this is important, my lord. I also collected corrective certificate regarding inventory of the sales exhibit. The sales exhibit A and D were sent for FSL examination. During investigation, inventory of the sales exhibit, the exhibit A and D were sent for FSL examination. During investigation, recorded the statement of the complainant, witnesses under section 161 CRPC, the apprehended accused persons were, my lord, interrogated and they confessed their guilt, my lord. Now, lordship, I will take your lordship to, my lord, paragraph section 52A of the NDPS Act, my lord. Section 52A, lordship will directly come to, my lord, subsection 2, my lord, A, B and C, my lord. My lord, after the seizure, my lord, the inventory was prepared, my lord, and it was placed before the magistrate. Now, my lord, as per section 52A, subclause 2, section 52A2, subclause A, my lord, certifying the correctness of the inventory so prepared, taking in the presence of such magistrate photographs of drugs, substances, or conveyances, and certifying such photographs as true, allowing to draw representative sample of each such drug or substances in the presence of such magistrate and certifying the correctness of list of samples so drawn by. So, my samples was taken from the packet, my lord. Although my understanding is that there were 3 packets, my lord, but from the, my lord, materials, my lord, that's it. Because, my lord, this is a bail application. This is not a quashing application. No decision, my lord, appeal that they were convicted, but there were such materials which was considered illegally considered by the trial court. That is why this is a bail application, my lord. It is not, my lord. It is a bail application, my lord, when the trial is going on, my lord. If lordship will make some observation, my lord, that no, it was 52A has not complied with, 42 not complied, my lord, the entire trial will vitiate, my lord. Now, my lord, I am again taking your lordship to 52A, my lord. Subsection 3, my lord. Where an application, my lord, this is important, where an application is made under subsection 2, the magistrate shall as soon as may be allow the application, my lord. Because application was have to file, my lord, before the inventory and, my lord, certifying. Now, 4, my lord. Notwithstanding anything contained in the Indian Evidence Act 1872 or the Code of Criminal Procedure 1973, every court trying an offence under this act shall treat the inventory, the photograph of narcotic drug, psychotropic substance, controlled substance or conveyances, and any list of samples drawn under subsection 2 as certified by the magistrate as primary evidence in respect of such offence. That means, my lord, whatever the inventory, certificates of photograph, and the samples, my lord, which was drawn and forwarded to the FSL, my lord, for FSL report, that may be, my lord, it is a primary evidence, my lord, in respect of the, my lord, offence, my lord. Now, lordship, in this case, my lord, admittedly, my lord, there was a prior information. They proceeded, my lord, by writing down the information through GD&P. The vehicle was searched, it was recovered, and it was found from the conscious person of both the accused person, my lord. And, my lord, everything was written down in the, my lord, search sheet, my lord. Because, my lord, this is a trial going on, midst of the trial, my lord. We cannot, my lord, take into consideration every aspect of the matter, my lord. Because 3 witnesses have been examined, all the 3 witnesses have implicated, my lord. Then it was seized from the conscious position of the accused person, my lord. And search sheet is very clear, my lord, as far as section 42 and 52A also, my lord. So, my humble submission, my lord, at least, my lord, section 37 will definitely apply, my lord. And it is not a fit case, my lord, to grant them bail at this stage, my lord. If there is no material after examining, my lord, 3 witnesses or 4 5 witnesses that it was witnesses have not implicated them directly or indirectly, then, my lord, there may be a case of bail. All the few cases they have implicated. So at this time, my lord, I oppose this bail application. And my learned friend have not supplied me, my lord, the citation he has cited, my lord. Because, my lord, I have to go through, my lord, if you want any reply in respect to citation in prospectus. So my humble submission thinks it is a bail application, my lord, when the trial is going on. So this is not a fit case to grant this bail, my lord, because if a lordship will make any observation, my lord, regarding 52 or 42 or any of the, my lord, section, my lord, then it will visit the trial. Hello, my lord.
I
Yes,
FIR or
no, item number 16 is different, my lord. Scan copy has been called for. I have perused the scan copy, my lord. And in this case, my lord, 3 accused persons are there. My accused, this present petitioner, ISA Begum, he was arrested. And other 2 accused persons, lordship, they were sworn absconded in the search sheet, my lord. And they are not appearing, my lord, in spite of someone is to them, my lord. So that is why, my lord, trial could not proceed, my lord.
My lord, so for 16, the violation of 42 is there. And now also, my lord, my learned friend has an answer whether the section 42 and the standing order has been complied in total. He has the case diary or scan copy, whatever it is. He could have pursued your lordship if really it has been added. Well, mere saying that we have added will not do. So these are serious matters. That's why, my lord, if the accused has any right in terms of, my lord, strict adherence to the section statutory provisions, that will have to be done in that manner. If you do not do, it's your fault. Therefore, they will have to convince your lordship that possibly he has failed to do that. Anyway, my lord, so now this is the next case. My lord, this, I will take your lordships to the FIR. At page, your lordship, kindly see at page 13. With due respect, I would like to inform that today on 11/10/2023 at 2 p.m., a reliable source of information, same thing, reliable source of information was provided by O.C. Rathabadi regarding narcotic drugs, that a large quantity of narcotic drugs had been kept concealed by one Asharuddin in his dwelling house located at so-and-so. It is revealed that the owner of the house, namely Asharuddin, is involved in illicit trafficking of narcotic drugs at the said locality. Accordingly, general diary entry was made by officer in charge of Rathabadi PS. Accordingly, written authorization letter was issued to me by Inspector so-and-so. The police party headed by me with the following police personnel. Now, your lordship may come to. I, along with the deputed police party, left to the PO. Your lordship may come to the last para. We reached the house of Asharuddin at 2:30 p.m. and our operation team has cordoned the house. And whereas the Asharuddin was not present in his house and his wife, namely Ayesha Begum, wife of so-and-so, was found present at home. Before we begin the search process, I identified myself before her and also offered on behalf of search party and myself to her to be searched the house. Therefore, prior to conducting search of the house for suspected banned substances, one local, namely Sania Begum, who was present at the PO and was made to conduct a body search of me and our entire operation team in presence of the independent witnesses, and apprehended accused Ayesha Begum, and then our team proceeded for searching house. The following items were recovered during the search: the house of Asharuddin. Page 14. 20 numbers of show boxes of various colors: blue, green, pink, cream, red and yellow. Now here they could locate pink. Now you also will find the 29 items of show box. Total weight is 992 grams. Number 2, 3 numbers of plastic packets. Regarding sampling, my argument will be the same as I have made in earlier case. 3 numbers of plastic packets wrapped by brown color adhesive tape. 1 olive green color school bag. During spot interrogation to Ayesha Begum, she revealed that yesterday on 10/11/2023, at evening hours, one Kamrul Islam brought the suspected drugs carrying into an olive green color bag and handed over to her husband, namely Asharuddin, and he left away. The suspected recovered heroin drugs was weighted by me with the help of digital weighing machine belonging to the Rathabadi PS in presence of witnesses, and the net weight was 992 grams. The above mentioned recovered items 1 to 29 were seized by me as per seizure memo in presence of the above mentioned 2 independent local witnesses. The seized drugs, heroin, were packed in a grey color carton box covered with white color marking cloths and sealed with law marks. The videograph and photograph of the entire search and seizure processes were taken by so and so. After completion of all these formalities, the police party departed from the place of occurrence and returned to the police station at so and so, so and so. It may be mentioned that I, being the women sub-inspector of police, I am empowered by the government of Assam by notification number so and so to make seize, arrest without authorization. I therefore request you to kindly register a case. Lordship may then come to the forwarding report, which is at page 16, the reason for arrest. At page 16, your Lordship will find that the accused persons were arrested on the following ground: large quantity of narcotics drugs suspected to be heroin were recovered from their possession. The arrested accused person confessed about their guilt before police. There is every possibility that the arrested person may involve in further committing such type of crime as they are desperate in nature. Then at page 17, the sigil list. The Lordship will find 3 numbers of plastic packets by brown color adhesive. Then 1 olive green color school bag where the suspected materials are there. Now it was handed over by Kamrul. She has kept it. She was not in conscious. It was Kamrul has handed over to Asharuddin. Then I will take your Lordships to page 16 once again to clarify thing. During spot interrogation, Lordship got it. During spot interrogation to Ayesha Begum, she revealed that yesterday on 10/10/2023, at evening hours, one Kamrul Islam brought the suspected drugs carrying into an olive green color bag and handed over to her husband, namely Asharuddin, and he left away. The suspected recovered heroin drugs was weighted by me with the help of digital, that your Lordship may skip. Now, this melody from this story, your Lordship can get the thing that Ayesha Begum did not have the conscious possession of the material. It was handed over by Mr. Kamrul Islam to Mr. Asharuddin. Now he left the place. Now, my lord, in a family, what happens? what sort of business he is doing, the wife hardly knows it. Now the person has come saying that some materials are there, you keep it, hand over, and it was handed over to her husband, and he has kept it and left the place. So the police came and they have searched the house and found that olive green bag, and they found that materials were there. Now question would be in regard to the conscious position, can I be held to be responsible to say that I was really knowing whatever materials was there? So therefore the question of conscious position, my lord, it is the duty of the prosecution. My lord, it is their burden, they will have to prove it, that really I had the conscious position of the material. And the number of plastic packets. How they had to. And then, my lord, these 3 packets, plastic packets, how it was, sampling how it was done. Your Lordship may come to page 26. Result of laboratory analysis, expert opinion and medical examination. Sravani Rajkot, Scientific Officer, Drugs and Narcotics Division, Director of Forensic Assam, opined that the exhibit DN so-and-so, dated so-and-so, gave positive test for narcotic drugs and psychotropic substances. Percentage of the exhibit was found to be 2.3.6. Now, my lord, there are 3 packets, but exhibit is only 1. Now, there is no explanation coming from the prosecution side whether the sampling was done from the 3 packets separately in terms of the standing order. These are totally absent. Now, my lord, if it has been from 1 packet, then 2 packets are free from that materials because sampling was never done. And the forensic examination in regard to those materials were also not conducted. So these are the very vital things my learned friend has submitted. These are the things to be examined at the time of when the inquiry, the entire trial will go on. My lord, even at the stage of, my lord, for the argument's sake, even at the stage of, my lord, consideration of bail application, if these materials are totally absent, my lord, this will go to show that the prosecution failed to prove their case. And if it is so, my lord, I cannot be found to be guilty. And, my lord, if I cannot be found to be guilty, the rigor of Section 37 will not come. And for the consideration of bail, my lord, these very materials, my lord, there are so many decisions as your lordship has seen. At the stage of consideration of bail application, your lordship can go into it. Merely by saying that we have complied 42, we have complied 52A, we have complied the conscious position, saying will not do. You will have to show from your record that you have adhered to all these statutory provisions which are in mandatory nature. So therefore, little right which has been given to the accused, my lord, if you can't comply, they are entitled to get the bail. And that much liberty, my lord, which has been available to them, it cannot be taken away by making a submission by the public prosecutor that we have complied everything. Now, mere saying, will you show from your record, you have the scan copy or whatever it is, they could not show in the earlier case, not even in this case. I don't think they have any. So these are the very vital things, my lord. And my lord, your lordship, kindly see the 1 and 6 years old baby, the mother, for a such infant here. The infant is, your lordship, kindly see the page 28. I have annexed the birth certificate of the baby. Your lordship will find he was born on 18/1/2023. 31 years. So 1 year, 6 or 7 months, my lord. This baby is with the mother. Now, what I, my lord, submit, there is a violation of 42(1) very clearly, my lord. Now, if you have done certain thing in a certain manner, my lord, Appeals Court has said you will have to do in that manner and no other way at all. So therefore, when you have, my lord, so far adherence of 42(1) has not been complied, my lord, it's a case where your lordship can, my lord, grant bail. Apart from this sympathetic consideration that a small baby is with the mother for such a long time. Now she has been in the custody for I think 250 days and all. Well, the decision which I have cited in earlier case will cover squarely in this case also. So far 42 and the sampling is concerned. These are the two grounds, and for other sympathetic considerations so for the young this lady and for her baby also. Should I conclude?
In this case, charge is yet to frame, my lord. Because all the charges has been submitted, and my lord, the other two accused persons, they are yet to appear before the trial court, my lord. So, my lord, he can, my lord, my learned senior, my lord, he can face all the materials, my lord, at the time of framing of charges, when the trial court may consider.
My lord, I don't seek any advice from my learned friend.
Now, my lord,
I know what I have to do.
As far as the, my lord, page number 18 hazard is, my lord. So, we will come to page number 18, my lord. Page 18, my lord. Lordship will find, my lord, place of seizure at house of Asaruddin, Khan of so-and-so. My lord, Asaruddin is the husband of this accused person, my lord. And, my lord, from whom she is, my lord, just below, my lord, from whom she is Ayesha Begum, my lord. She is the wife of Asaruddin. Now, my lord, this is also, my lord, after receiving a prior information, Lordship, they have proceeded. And, my lord, it was, my lord, it is mentioned in 13, my lord. This is the FIR. When the, my lord, the entry was made, my lord, when the information was received, thereafter, my lord, accordingly, written authorization letter was issued to me, my lord, by Inspector Uttam Modikari, OC Ratabari PS, by DD number so-and-so of the PS, who is empowered by Government of Assam by notification number so-and-so, that is so-and-so, under section 41(2) of the NDPS Act, to issue such authorization. Thereafter, my lord, they have proceeded, search was conducted, and this contraband was recovered, which is, my lord, commercial quantity. And, my lord, if your lordship go by the, my lord, scan copy of the record, my lord, the witnesses implicated this wife also, my lord. She is equally, my lord, involved in the, my lord, commission of crime, my lord, along with her husband. Because these are the organized crime, my lord. NDPS Act, it is our organized crime, my lord. He was very much involved in this case, my lord, as per the statement, my lord, witnesses recorded by the IO, my lord. So I oppose this bail application, so I appeal this one.
My lord, we have also social responsibility. We also want, my lord, drug-free India. But where, my lord, the statutory violation is there, my lord, that should be looked into, my lord. Because, my lord, is a thing where the statute has given that right to the accused person. If it is strictly to be applied in the case of accused, it will have to be applied in case of prosecution also. Therefore, for drug-free India, everybody wants. It's not that, my lord, there is some material and that should not be looked into. And my learned friend is arguing just casually the routine type argument in every case we see. And who are the witnesses implicated me? I fail to understand. Evidence hasn't been started yet.
No, my lord, these are the witnesses on the basis of which search is submitted, lordship.
Those are the stock witnesses, they are police people.
That is why also that is why I have submitted, lordship. If there is a case, lordship, we can definitely say at the time of framing search, because trial court will definitely consider, my lord, the witnesses at the time of framing search. If there is no material, my lord, if there is no material that, my lord, his wife is not at all involved, or his petitioner is not at all involved, he will be definitely discharged, my lord. But at this stage, my lord, before framing of charge, lordship, how can be, my lord, this court will, my lord, come to a conclusion that, my lord, this lady is not involved, my lord. And such result is very, very clear, lordship, which is from our position, my lord.
Lord, my public process failing to understand one thing. We are not saying that they should not be convicted. If they are involved, they will be convicted. But for the granting of bail at this stage, I have some material and I have focused all that. Have you replied to that?
Then, my lord,
give reply to that.
Draw satisfaction as far as section 37 is concerned, lordship.
37?
There is no material, lordship. Let my learned friend, my lord, give some, my lord, conclusion that there is no such material, Lordship. This is the first conclusion, my Lord.
First conclusion
And
is the
after
last.
releasing of bail, my Lord, he will not involve in this offense again. Just 37 accused, satisfactory ground, my Lord.
On 37, my lord, how is to be applied? My lord, I have argued. I think my learned friend hasn't followed it. God bless.
So, talk to hello.
Lord,
What?
he has agreed to it if it is matter is fixed on Monday. Lord. Yeah.
24. It is
20. Most of it.
well, yeah. What 7?
Petitioner is absent, but in this case, charge is committed.
And it the other will pass.
Let him appear, my Lord.
Yes, it,
My Lord.
okay.
May I please allow? My lord, this is intermediate quantity lordship, and the petitioner is already behind the bar for 54 days now.
My Lord, yes, there are materials, my Lord, in the case diary, my Lord, but FSL is pending for FSL, my Lord. Otherwise, my Lord, the other part of the investigation has already been completed.
My lord, considering the
This
length
is
of
from his position, my Lord.
Of the
60 days, my Lord, or is the intermediate one.
and yes, then one second and 20 of certain then it 4-5 days it started stage or then we are so
Fine.
that it takes some time. Without looking at very good
From my
because it's more than one how it
fine.
considering the length of
CD is already
Yes, that is it, my Lord.
how many times?
only one.
Special of Bongaigaon. Oblast.
What?
May please Lordship, today is 54 days intermediate 2020. Length of detection. My lord, in this case also we have received the case data, but FSL report is pending, Lordship. We have entered from the police station, my lord, they have not received the FSL report. Now, my lord, in this case, my lord, one Ilzamamul Ali was, my lord, apprehended, my lord, and from his possession, my lord, 7 grams of heroin was recovered. Then he implicated, my lord, this accused person, Abdul Ali, my lord. Then his house was searched, my lord, then, my lord, 9.170 grams from received from his possession, my lord. But they are peddler, my lord.
Otherwise, they are peddler.
It is pending for to collect the FSL report, which is not ready. We have been informed. Otherwise, materials already collected by the investigative officer against this person.
What report?
So that will come on Monday, my lord. Monday or Tuesday.
Lordship,
Otherwise,
on the length of detention, Lordship, his wife is about 8 months running pregnancy. Lord.
Monday,
We may again, my lord. That is fixed on Tuesday, Lordship. On 25th.
The Lordship, other accused Lordship already granted bail of the Sessions Judge Lordship Borfeta Lord. Without schedule. Without schedule, Lordship, the charge is not submitted, Lord.
No,
The
there are
today's
time,
information, Lordship.
It's a 60 days offense, my lord.
On the length of detention, Lordship.
That's what I'm asking. Is that I just said that
Yes, my lord.
so he may be the
My lord.
or there may be other then FSL is the power.
Yes,
Or
please.
yes, with the so it consistent and it body other
Yes,
but
my
that
lord.
comes. I also know that though it's
Because CTS, my lord,
they are serious.
it is lying before us, Lordship. For to file such a Lordship, they have to obtain the FSL report, then they have to take back the case verified.
Further input or take it further input.
My lord, we can make it, my lord, but let it come on Monday, Lord. Monday,
Lordship,
my lord, they have not received the FSL report, my lord. Lordship will pass this.
Lordship, on length of detention, his wife is Lordship only 8 months running, Lordship, in the record is there.
Please stop. Really take it up. Take it that word not
The only implicated, Lordship, only implicated the accused person in Jamul Haq. He's already, Lordship,
My lord, contact also recovered, Lordship.
the
So,
Lordship,
mere implication, my lord.
the Lordship, the petition is the habitual addict person, Lordship, drugs addict person.
obviously there has to be a statement from the court, is otherwise during inquiry there should be only
He is on the addict person, Lordship. I admitted, Lordship.
he is addict.
Addict, Lordship. On the length of detention, Lordship, consider the bail petition. His wife is
Monday.
already.
Lordship, may I beg Lordship's indulgence for mentioning one matter, my Lord, which is listed before your Lordship today. But maybe, Lordship, it's just a small application, my Lord. It's an interlocutory application to modify a bail order to release the passport. Today, my Lord, I understand, my Lord, bail matters are still pending, my Lord. It's about liberty. So may I pray, my Lord, that my small matters may be fixed on Tuesday at 2 p.m., my Lord. Because it's for release of passport, my application will become futile. 58 and 78, connected, my Lord, out of the same case. Both are interlocutory applications, my Lord. 58 of the daily list and 78 of the supplementary list, my Lord. So next week I have to travel, my lord, first week of July, so that is why, my lord. The matters don't reach, my lord.
For monthly budget. Yeah, we picked it on Tuesday, but let us see what happens.
My lord, Tuesday at 2, my lord, if possible, my lord, because next week we have to travel,
I
my
won't
lord.
say now. You just remind me.
My lord,
In the
Tuesday I
morning
will mention in the morning, my lord. Tuesday I will mention in the morning. 58 and 78. my lord. Deeply obliged. Deeply obliged.
Petition stands.
Obliged, Lordship.
May I please, Lordship? I am for petitioner, Lordship.
Oh. Put the petition stands.
Obliged.
1111 and 1.
Obliged.
Court finds that the present petitioner do not suffer from any, the order do not suffer from any illegality, impropriety, and correctness, and hence the petition stands.
Thank you.
This petition also stands.
Highly obliged. Obliged.
Please, Lordship. Lordship, kindly adjourn this matter for today, Lordship. And Lordship, fixed on, may prefer fixed on 27th of this month.
Oh, in the morning count, so it is 16 to 2.
Lordship, Mr. Rashid Ahmed will argue this case. He appear on this case, Lordship.
So you want to fix it up?
He is not, he has difficulty to appear with the Lordship.
Next week it won't be possible.
Lordship, then after vacation,
After vacation.
immediately after vacation, Lordship. On
What kind of material? This is the, the
commercial quantity, Lordship.
commercial quantity.
On 18th, Lordship, 18th.
Huh?
18th, Lordship.
On it can be fixed. Okay.
May I praise Lordship? May I praise Lordship? This is 439 regular bail application, Lordship. As on today, 68 is custody, Lordship. And the informant also appear before this court, Lordship.
Your Honor, I am appearing for the informant. I have no objection.
In this case, Lordship, what happened? The girl is from Guwahati and boy is from West Bengal. She voluntarily went to the house of the petitioner, Lordship, and stayed 15 days in my absence, petitioner's absence, because petitioner is working at Bangalore in a private company, Lordship. And repeated asked by the guardian of the petitioner, Lordship, he came from Bangalore and thereafter they have got marriage, Lordship. This is the case, Lordship.
Otherwise, it affects the statistics of the box.
Today we have not received the case diary, my lord, but we have inquired, my lord. Can it be taken up after some time, Lordship, whether search submitted or not, my lord? Because the section 6 of POCSO is involved, my lord. So, my lord, perusal of the case diary is necessary, my lord.
From my knowledge, the police already submit charge sheet, but I have no certified copy obtained till today. Already submit charge sheet.
That information was we have to
And this is the third day.
After some time, Lordship.
This is the third day. They have not brought any case diary, not any charge sheet. They have not complied the order of this court, Lordship.
Today itself, my lord, only after some time, my lord. We just obtain instruction whether search is submitted or not.
After some.
Obvious, Lordship.
May it please your lordship. My lord, a scanned copy of the court proceeding has been brought before your lordship, my lord. My lord, the accused petitioner is a accused person in a session case 50 of 2013. Now the case is pending in the court of Session Judge Paringar. My lord, initially he was granted bail, my lord, and the case was charge sheeted. Then what happened, my lord, for the pursuit of life, he changed his place of residence, and he was also informed by his concerned advocate the case is not proceeding. So he was not cooperating, my lord, and the bail bond was also cancelled. Later on, when he shifted and came back to his home place, my lord, he was again informed by the informant and he was arrested. Now he is in custody since 3/5/2024, my lord. For about 50 days, he is in custody. My lord, I go back to draw your lordship attention to page 15, the rejection order of his bail by the learned session judge. Where from in the background of the matter appears before your lordships. Page 15, your lordship might have got. Accused Abdul Basit is produced from the judicial custody by BC. He is remanded back to jail custody till 29/5/2024. Seen petition number so-and-so filed by accused seeking bail. The petition is supported by an affidavit, heard both sides, perused, CR. It is submitted by the learned counsel for the accused that after the alleged incident, the accused persons were driven out from the area. During the investigation, TIP was done, and as the victim identified the accused person, police filed charge sheet against them, and in course of time, case was committed and one PW was examined. Thereafter, when forced out, the accused started living in Hailakandi and informed his counsel about the change of his address, but his learned advocate did not take steps for which the warrant of arrest issued against the accused. It is further submitted that in the month of October 2013, the accused met his learned advocate who told him the case was filed by order dated 3/9/2014, and the accused thought the case was disposed of, not understanding the meaning of the word filed, and CIS also showed the case to be disposed of. That in a village meet, the informant told the villagers case was disposed of and the accused was not the real culprit, for which he was allowed to return to his original house. But on 3/5/2024, the police arrested the accused. It is further submitted that on 3/5/2013, the PW2 and PW3 were examined and they have not mentioned the name of the accused. That the informant filed a petition before the court referring the accused as convict and informed that he was in locality for which order to issue warrant of arrest was issued, passed, and thereafter accused arrested, and since he has been in judicial custody, accordingly prayed for grant of bail. Concerning the materials available before the court of so-and-so, warrant of arrest has been pending against the accused, Abdul Basit along with two others, and bailment of their bailers have been forfeited. All of the facts appears from the court that he was once granted bail, he was then thereafter misunderstanding the fact that the case has been filed and his concerned advocate who was dealing with the matter, through whom he was granted bail, also misinformed him. And that apart, my lord, CIS also reflected the case has been filed, so the confusion arose. Whatsoever the fact, my lord, now she is very much in custody for about 50 days. And my lord, the case is under trial. So he said maybe kindly, he's a local person, my lord. He will go with sufficient bail bond and he will definitely cooperate. Otherwise, he will be again held up, my lord. So I pray before your lordships, considering the background of the matter, the case is in trial and he is a person, local person with sufficient bail bond. He may be enlarged so that his right under Article 21 to defend himself may be allowed, my lord. Otherwise, he will be seriously prejudiced in the eye of law, my lord. So I leave it before lawsuit's consideration, my lord. Considering the length of detention and the matter is under trial, he has to defend himself. Your lordship may please.
He is the only accused or other accused?
My lord?
He was the only accused?
No, other accused are also there, man. Other accused are also there. And I have drawn your lordship attention that two PWs who were examined, they did not mention the name of the accused person. That apart, my lord, your lordship may also kindly consider page 18, a medical report, wherefrom it appears that no such incidents so far the girl concerned was there. There was no reflection of any source of injury on her person. And this is a different thing, my lord. It will be considered during the trial. But the facts remain that he is under custody for about 50 days, not about 50 days, my lord. So he may be allowed to go on bail with sufficient surety and he will defend himself. Otherwise, his right under Article 21 of the Constitution will be frustrated. This is my humble prayer for lordships.
Lordship, there are three numbers of accused. And as per the record, Lordship, accused present on 16/5/2023, because there is a FIR dated 2012 matter. After committal on 16/5/2023, the charges were framed. And after that, Lordship, 16/5/2023, I have already flag marked the... sorry, Lordship, 2013, Lordship. Yes. 16/5/2013,
as per record, my lord.
As per record, that is the charges were framed. And then thereafter, Lordship, after 16/5/2013, Lordship, all accused, including present petitioner, they never appeared. They are the proclaimed absconder. PA was that is made, and 19/2014, that is the PA made absolute, and the hearing of the prosecutrix was done on 3/9/2014, and an interim compensation was granted. And on 3/5/2014, Lordship, a complaint was filed by the mother of the victim, and on the basis of that, he was then again the non-bailable warrant of arrest was issued. And on 3/5/2014, on the strength of that, he was arrested. Now he is in study. Now that is his conduct. And not only he, the present accused petitioner, other two are also the same way. They are also.
He is according to his valid 16/5.
Lordship, after 16/5/2013.
That could be PWs or exam.
PWs, Lordship, PW2 is the victim.
So they were already exam.
Yeah, PW2 is the victim.
But you have said that 65% is absent.
Lordship, 37/2013 reflects all accused are absent. And their bailers are called. 13/7/2013, Lord.
know about when PWs were examined.
Lordship, that is, I have flag marked this PW2. I forgot the date, Lordship. PW2 is the victim, Lordship. And CW1, that is.
May not P9. P9 40 50 was as a PW. Then PW3 is also examined.
My lord, my learned friend has nicely submitted from the records, my lord, and it is correct. I beg to draw your lordship attention to page 16 of my petition, my lord. Kindly, page 16 of my petition, your lordship kindly see. Page 16, man. Page 16 of your lordship kindly see my petition. It is the order. It is from the order passed by the learned session judge. Paragraph 6, my lord. Your lordship might have got it. It is further submitted that on 3/5/2013, the PW2 and 3, or PW2, my learned friend is telling the victim herself. PW2 and 3 were examined, and they have not mentioned the name of the accused. He is a local people, my lord. He was well aware of the fact that he was very much cooperating with the complainant party. And on that belief, my lord.
This is your subject.
Yes. My lord.
It is not the court.
Yes.
Your subject.
So, my lord, my facts remind that he is in custody for 40 days. And he is a local person, my lord. He has to defend himself. And he will sufficient bail bond, my lord. He may be allowed to go on. He will cooperate definitely, my lord. Other the change of law is there. So for the ends of justice, as to defend himself, he should, my lord. And he has believed, my lord, there is nothing against him in the case. Only because of the fault that he was not available in the place because of the pursuit of life, he went elsewhere. So a bail bond was cancelled. And the learned advocate with whom he was defending also not properly instructed him, my lord. A layman, my lord. So considering this fact of length of and the right of his defense himself, your lordship may be pleased to grant him bail, my lord, with sufficient bail bond so that he remain in a tight position and cooperate with the proceedings, my lord. The matter is going on. This is 2013 matter. It will not take much time, my lord, I believe, because most of the PWs have already been examined. So I kindly pray before the lordships to consider his bail for the ends of justice, my lord.
Scan of the case that he was not but artist that where he was working.
My lord?
He was working in Hailakandi.
He was shifted to Hailakandi, my lord.
Earlier he was staying.
He hails from Karimganj, the locality from where the
the and it form and it comes about it but it not comes not it of that it for it um uh there from the 14 it came from it when he inquired about it was known that as part it was and then it was under it and was or not accepted that however when he completed it was at it the uh, 3-5 the it's a problem but it has now wanted rather proper and this bad part of the that which and not take the proper form and this form rather give us it not not take the frame make it doesn't but I don't on okay. If, and if then depends on on the that and on complain by the micro on for it get the correct get the but side that they are not for that but that not and what but this can populate can populate from reports that after energy it was something they had charge on 65,000 then there for X on at 6 but instead they could mentioned that would be or learning system that's very much or should not be others, but the kind of yes, and as that can go to your questions then.
The medical report from jail was sought for.
This after some time, we have again contacted the jail or jail doctor. They are sending a report. After some time,
You will send the report.
they will send the report. Again.
Maybe after some time. Here is a case, Lordship, whatever 2% were caught, Lordship, with 2% was caught, Lordship, with 21.3 grams of heroin, Lordship. From 2% pillion rider were there, Lordship. From their each pocket, Lordship, and total it was 21.3 gram, Lordship. That means it will come around 10.5 gram. 1.5 Lordship, sorry. 21.3 gram, Lordship. From position of 2%, Lordship, separate packet, Lordship. Total weight is 21.3, Lordship. 50 days, Lordship.
We have received the case diary, my lord. From the CSRD, it is from both the accused person, lord. And my lord, today is around 50 days, my lord. It is pending for SSL.
Kindly, Lordship, allow, Lordship. 50 days already spent, Lordship. Vacation is also there. Kindly.
FSL report they have not collected, lord. It is not ready, my lord. But we have been informed from the police station.
10 4 days.
10 4 days.
Kindly, Lordship, 50 days already, Lordship. Each person, Lordship, will see 2%, it was recovered 21 gram, Lordship. It will be lesser quantity, Lordship. Kindly, Lordship. From 2%, Lordship, 2 packets were recovered, and total weight is 21.3 gram, Lordship. Much lesser than the Lordship, that 250 grams. Kindly, Lordship, that they are, Lordship, consume that, Lordship, for consuming, not they are seller, Lordship, not peddlers, Lordship. Kindly, Lordship. Already spent 50 days.
CD, did any that they are supposed to be peddlers or merely consume?
It is not directly.
Nowhere in forwarding and peddler, nowhere it is mentioned. They consume it, Lordship. On a both were club, Lordship, so it has become 21 gram, Lordship. Kindly, Lordship, 50 days, Lordship. Peddler will mention it. Any forwarding a peddler will mention it.
So it is not mentioned, but they are peddlers or not, that is not mentioned in that statement.
Whether they brought those things for, selling those things as a peddler is not mentioned.
And it is not mentioned, my lord. Only, my lord, it is mentioned that, my lord, desired places, they have, it is from their possession, my lord.
Either it's okay,
My lord.
otherwise any other method.
Otherwise, my lord, no, desired places have been examined, my lord, and it is from their possession, my lord. That is
Other cases we normally see in forwarding report, they says they have previous record, they deal with this, that nothing has been mentioned in the forwarding report, Lordship. And normally other cases we always see, Lordship, that they are peddlers, they are involved in other cases, that has been always reflected in the forwarding report, Lordship. They consume it as a very small quantity, Lordship. From both pocket, Lordship, we clearly reveal from the FIR as well as from the forwarding report, Lordship. From 2% it has been required and total weight is 21.3 gram, Lordship. Very small quantity, Lordship. Consumable, Lordship, amount.
They said, Lordship, one Naga person has gave to them for their self-consumption.
That's part them.
Yes, they are accepted. His name is not mentioned. Naga person name has not been mentioned, my lord. But they have given to them for their consumption.
Consider witness both it recovered was made from both one point but but other and for this report but as it from Naka person on what come up and have some as not common as everything that I but Where from where this
Hey, special just Difu Karbial.
might happen. They are from which place?
Lots of they are residing in Karbialong, but they are from Manipur, Lordship. One is from Nagaland, one is from Manipur, but their present address is Karbialong, Lordship, from nearby. Much obliged, Your Lord. Much obliged. Much.
We have received the information, my lord. That is submitted, my lord.
Now, why because there are some indications, undoubtedly, he has submitted that she went by her own, and thereafter they got married. But it's admitted fact that the girl was a minor.
Minor. And that is an admitted fact.
And that apart, they stayed as a husband and wife, so section 6 will definitely come. But why you are submitting that you don't have any objection?
Because, Your Honor, already they have been.
Again, or Mr. Borua, we have another 3 prayer matters.
My lord.
One prayer is there from Rosary.
My lord.
Take up one matter at 3.
My lord.
3 matters have already only 3 matters left, so kept with 3 matters.
My lord.
And where 3 matters left with us is the 46, 47 and 49.
My lord, 46, 47, 48 and 49, we have not received the case diary.
48, one prayer was made in the morning hour. For then it was picked up with 6, 7 in fact.
No, my lord.
And what about 46?
46, my lord. 46, we have not received the case diary, my lord, and the accused person is on inquiry, my lord.
46
and come after vacation. 22/7. My lord. Uh, 47 also we have not received the case diary, my lord. The accused person is an inquiry.
Okay, same order. It will be 22 or
My lord.
what about 49? You are
They are interim orders not there, Lord.
but we have 5. We have received the case diary.
Case diary not received, my lord. Immediately after reopening, my lord.
Lordship, kindly next week, Lordship. Otherwise, Lordship will. Yeah, Lordship in this app.
These are all, NDPS matters. So CD will be required. We don't have.
Lordship, that's why, Lordship, next week, Lordship. And next Friday, Lordship.
Not at all possible.
Otherwise,
That
Lordship.
apart, Monday, Tuesday, Wednesday, I am having my PD interview. So
Otherwise,
those
Lordship.
will rise early in fact.
Otherwise, Lordship. Yes, because Lordship, it is.
Since when he is in custody, just tell us.
No, Lord. AB, Lordship.
Oh, it's a AB.
Yes.
Then it's okay. After. It's an NDPS matter.
Yes, Lordship.
After
19 months.
It's according to 9. Just after vacation, we are
My lord.
on 19.
Lordship, if possible, Lordship, 18 on, if possible.
Do you have any problem on 19?
At 18 if possible, Lordship.
Do you have any problem on 19?
Lordship, it is got. I have
You have problem. Okay.
18.
Okay, and on 19, 18.
Hello.
So here, respondent number is MA
Lordship.
Oh,
He is there.
so you are applying for 2 and state is for 1, I think.
Yes, Lordship. This is an application under 482, Lordship, for quashing of the Lordship that
we have not forget to that I took up the matter. I mean, I have
Lordship. Already, today is maybe the 6th day, Lordship.
Yes, on the last occasion, most probably you
Lordship.
submitted in that manner.
Lordship,
So I
due
thought
to
that
paucity of
every
time, we could not reach every day. This 482 application regarding Lordship quashment of charge sheet by number 261 2023 under section 120B 420 468 471 Lordship. In this case, what happened, Lordship? One owner of a plot of land, Lordship, wanted to sell his property to the Lordship purchaser. Both of them, Lordship, executed a deed of agreement, and thereafter they came to my chamber for Lordship correction of that deed of agreement, Lordship. Then I made some corrections in the deed of agreement, then they left, Lordship. Thereafter, the sale deed was prepared by me. I am an advocate, Lordship. The petitioner is an advocate. So thereafter, we came to know that there was an FIR by the S. Kanongo and the officers of the Lordship from the deceased office, that the NOC which is obtained in execution of the sale deed, it was fraudulently obtained. In that regard, there is a direction from ADC to file an FIR, and then again, Lordship, to not to file an FIR. Those I have annexed as Annexure 1, page 17, Lordship. The entire dispute is regarding the NOC, Lordship. Page 17, Lordship, cancellation of NOC.
So petitioner is the
Advocate, Lordship. Page 17, Annexure 1, Lordship. As
This
per
is
your
for cancellation.
Lordship.
This is for cancellation of NOC.
No, Lordship. Before filing the FIR, there is a direction from ADC to lodge an FIR, Lordship. This is a direction from ADC to the circle officer that as per your report, it's seen that Sri Sudipta Das Amin and Sri Ranalal De have denied the fact that they have not put their signature in the NOC covered by so-and-so, where Vendi was Sri Raju Ghosh, he is the purchaser, and vendor was Purnendra Kumar Saha. In view of the above, you are requested to direct Sri S. Das Amin and Sri Ranalal De SK to file an FIR. On failure to do so, necessary action will be initiated from this office. So there is a direction that both of them were directed to file an FIR as their signatures were fraudulently taken in the NOC, Lordship. They denied that they have not put their signature in the NOC, so the NOC was fraudulently taken from deceased office, Lordship. And next page, Lordship, page 18. In pursuance of order in the Learned Court of Civil Judge Karimganj against title suit number so a compromise decree in term of petition number so considering fact of the suit being compromised between the parties with Sri Raju Ghosh plaintiff versus Sri Purnendra Kumar Saha defendant, and in pursuance of joint secretary to the Government of Assam Revenue and DM Department wide letter number so wide government notification number so the registration of Assam Amendment Act 2021 expedite the process of registration for transfer of or lease of flat or residential apartment, etc., which received the assent of the Honorable President of India on 25th February 2022. Therefore, deviation to laws means there is a direction not to lodge the FIR, Lordship. by Sri S. Das Amin and Sri Ranalal De SK does not arise. Hence, copy of this office letter number so 4/2/2022, that is the earlier order, Lordship, returned back to the undersigned urgently. So, as there was a compromise between the purchaser and the seller, as the seller did not want to sell the property later on after the deed of agreement, the purchaser filed a title suit for specific performance of contract. After that suit, Lordship, they both of them compromised, then the seller sold off the land to the purchaser, Lordship. So there is a direction that no need to file any FIR. Even then, Lordship, thereafter an FIR was filed. That is page 19, Annexure 3. This is the translated copy. By 2 persons, 1 FIR, Lordship. It is most respectfully stated that we are the permanent residents of addresses stated above. I, the petitioner number 1, is at present working as Amin in the office of Karimganj Sadar Circle. I, the petitioner number 2, was working as SK in the same office but have retired from service on 30/7/2021. We came to know from reliable sources that on last 29/2021, one NOC was issued from the office of the Deputy Commissioner Karimganj, Bhait number so-and-so. For issuance of the said NOC, we did not submit any report from the circle office. Subsequently, we came to know that on last 11/11/2020, some unknown persons, by forging our signatures, submitted the inquiry report. Subsequently, during re-verification, the previous report was submitted once again by forging the signature of the petitioner number 1. As the petitioner number 2 retired from service during that period, the then incumbent SK put his signature on the report. So re-verification was done and again the NOC was obtained, Lordship. Under such circumstances, it is prayed to Your Honor that the aforesaid incident may be investigated and necessary action. So this is the FIR. Now, charge sheet, Lordship. And after this FIR, I came to High Court and I have granted bail by this court, that is Annexure 4 AB 1630 of 2022. Relevant portion, page 27. It appears that in view of the interim order dated so-and-so, the applicant appeared before the IO and his statement has been recorded. Further, it appears that he has been cooperating with the investigating agency and there is no material in the case diary to show that the applicant has misused the liberty granted to him by the interim order dated so-and-so. In view of the progress of investigation and also in view of the materials collected so far against the petitioner, against the applicant, and the facts and the aforementioned facts and circumstances, as well as the submissions of the learned advocates of both sides, this court is inclined to make the interim order dated so-and-so absolute. So absolute bail was granted to the petitioner. Now, charge sheet, Lordship, this is page 29, Annexure 5. Second paragraph. During investigation, the informant and witnesses were interrogated, documents were collected, seized, and got it seen by the Honorable Court. Statements of witnesses were recorded before the Honorable Court. Raju Ghosh, this is the purchaser, son of Mihir Kanti Chanda. This is wrong, Lordship. He is son of late Naresh Chandra Ghosh. Involved in the case was arrested and produced before the Honorable Court in the statement of accused Raju Ghosh, son of late Naresh Chandra Ghosh. So the entire charge sheet was very mechanically prepared. Of Shivbari Road, PSN District, Karimganj, it is reflected that in the residence of Advocate Arijit Dasgupta, son of late Ashish Bhushan Dasgupta of Shambhu Sagar Park, PSN District, Karimganj, Assam, the official work was done and he paid rupees 2 lakhs to Arun Kumar Das. So amount was paid to some Arun Kumar Das, alias Manna, to perform the official work. See, Arun Kumar Das alias Manna, son of Anil Chandra Das of Banmali Gopalbari Road, PSN District, Karimganj, having obtained anticipatory bail from the Honorable High Court, appeared before the police station, but as the bail was not made absolute, he was tried to arrest, but he could not be traced out. As Advocate Arijit Dasgupta obtained pre-arrest bail from the Honorable High Court, he was refrained from being arrested. Though Purnendu Kumar Saha has sold the land, but the seller fraudulently obtained the documents without maintaining the due official work. The clear allegation is against Purnendu Kumar Saha, seller. During investigation, having taken the specimen signatures of informants and suspected persons were sent to FSL, and in the report as the signature of Mihir Kanti Chando tallied with the signature of forged document, Sri Mihir Kanti Chando, 62 years, District Karimganj, was arrested and was sent to judicial custody. During investigation, it appears that Sri Raju Ghosh, Advocate Arijit Dasgupta, Arun Kumar Das alias Manna, Mihir Kanti Das, by plotting together, forged the documents and obtained the documents from government office and thereby purchased the land. Therefore, offence under censorship. So, in the entire scenario of the charge sheet, there is no allegation that against the Arijit Lordship. Only allegation against Purnendu, but in the charge sheet, his name is not there. Purnendu's name is not there. Only 4 accused persons. Page 32. Accused number 1 is Raju Ghosh. That is the purchaser. Page number 33, Mihir Kanti Chando, whose signature tallied with the fraudulent signature as alleged. 3rd, the petitioner. And 4th, Arun Kumar Das, page 34. So the charge sheet says there is at the instance of the seller, the NOC was prepared, but in fact the entire charge sheet, he is not the accused. His name is not there. In the 4 accused persons were sent for trial. So with these allegations, these 4 persons were sent for trial. And order sheet, page 38, annexure 6. CR is received on transfer for disposal. Peruse the CR, charge sheet is submitted against the accused persons, namely so-and-so. On perusal of the CR, it is found that there are prima facie materials to proceed against the accused persons. Accordingly, cognizance is taken against the above named accused persons under sections 120B, 420, 468, 471. I have annexed the notice, 160 notice, which was sent to me, page 39, and accordingly I appeared before the IO. And after that, when they again called me, then I took interim bail from this court. Now the FSL reports, your Lordship will find page 41. Serial number 6. Blue enclosed standard writings and signatures of Arijit Dasgupta stamp marked as S47 to S55 in 2 sheets. So his signatures were S47, S55, and findings page 42. 6.4. The person who wrote the blue enclosed writings and signatures stamped and marked as S47 to S55 did not write the red enclosed writings and signatures similarly stamped and marked as Q1 and Q8. Q1, Q8 are the signatures in the NOC. That is mentioned in page 41, question, red enclosed writings and signatures stamped and marked Q1 to Q8 in an NOC form, inquiry report in 1 sheet. So his signature did not match with in the FSL report also. Now page 44. The documents in connection with the above mentioned case have been carefully and thoroughly examined and compared the disputed writings and signatures with the supplied standard writings in all aspects of handwriting identifications and detection of forgery with the help of various scientific instruments such as DocuCenter Expert BSc Senso under different light arrangements and magnifications. The person who wrote the blue endorsed writings and signatures stamped and marked as S83, S86 also wrote the red enclosed writings similarly stamped and marked Q1, Q6. It has not been possible to fix the authorship of the red enclosed signatures marked Q7, Q8 on the basis of comparison with the standard materials at hand. So S83, S86 are the signatures of this Mihir Kanti Chando. Now some of the statements I have enclosed along with this petition as Annexure 9, Raju Ghosh statement. Page 45. On being asked, he stated that his name and address mentioned above are true. I have a business of vegetable. One day Sri Purnendu Kumar Saha came to my residence and told that he would sell a plot of land, but as the price of the land was not agreeable, the transaction could not take place. Subsequently, as he decreased the price, I agreed to purchase the land, although he initially stated the price of the land to be rupees 1 crore 30 lakh, but subsequently it was fixed at rupees 1 crore 16 lakh. At the time of agreement, the price of the land was shown as rupees 16 lakh. I, after consulting my advocate Arijit Das, engaged Sri Ashim Kumar De to draft the same, and Purnendu Kumar also agreed to the same. On the day of agreement, rupees 5 lakh was paid and subsequently rupees 11 lakh. The said transaction was also taken down. Remaining amount was not taken down. I paid rupees 1 crore 14 lakh to Sri Sendhu Sheikh, 11 lakh to Sri Sumit Dev, 4 lakh to Babul, 46 lakh at Punjab National Bank, rupees 9,000 as electricity bill, rupees 25,000 to advocate Arijit Dasgupta, rupees 5 lakh to Subrato Das, and cash amount to Purnendu Kumar Saha. So there are some loan of Purnendu Saha to different persons, so he paid the amount to different persons in favor of Purnendu Saha. Purnendu told me that he has to return the borrowed money to them. I have returned the payment of some money in paper. I have paid rupees 2 lakh to Manna alias Arun Das, which was payable to him by Purnendu. Arun asked money from me, saying that if money is paid to the office, the works will be done promptly. But I do not know how much he paid to whom. So Arun asked money from me, saying that if money is paid to the office. So Arun asked money and Raju Ghosh paid. There is no mention of advocate. Statement of Ashim Kumar De, he is the deed writer. That is page 48, Annexure 10. On being asked, he stated that his name and address mentioned above are true. I am an advocate's clerk, deed writer. On last 29/9/2020, Raju Ghosh and Purnendu Kumar Saha came to Sub-Registrar's office and asked me to prepare an agreement for sale of land, saying that Purnendu will sell the land and Raju Ghosh will purchase. I drafted the same. Thereafter, I, along with Raju Ghosh and Purnendu, went to the residence of Advocate Arijit. After verification, the final copy was printed out. On stamp and signatures were put at the residence of Arijit and handed over the same to Raju Ghosh. I have filled up the form. Few days after handing over the same, I came across Raju Ghosh at Main Road. On being met at Settlement Main Road, Raju Ghosh took me to Circle Office. At the Circle Office, Arun Das was found, and in front of me the form was given to Arun Das. So that form was also given to Arun Das. There is no mention that anything was done by petitioner. Only the deed of agreement was taken to his chamber. He corrected, then the final copy was taken out. And thereafter, after obtaining NOC by the purchaser and seller through one Arun Das, the sale deed was drafted by the advocate. After handing over the said paper to Arun Das, I returned back. What happened thereafter, I do not know. Now Annexure 11, page 51, that is the deposition of Ashim Kumar De, 164 statement. That on 29/9/20, Raju Ghosh and Purnendu Saha came to the Sub-Registrar office where I was working as deed writer. They informed that one Purnendu Saha wanted to sell his land to one Raju Ghosh. I accordingly prepared the draft and we went along with the draft to one Arijit Dasgupta. Advocate House as requested by the parties. The draft was checked and minor corrections made there, and I have brought the final copy to print on stamp paper. I again took the final copy to the house of Arijit Dasgupta and they signed there. Along with the agreement for sale, we have also filled up the application for seeking NOC to sell the land, and both the parties signed on NOC and the same was handed over to one Raju Ghosh. Thereafter, we all came to the sub-registrar office and thereafter we signed the final copy of the said draft and submitted before the sub-registrar office Karimganj. On the same day, the parties have executed one power of attorney, but I do not remember the contents of the said power of attorney. After many days, I met Raju Ghosh at Settlement Road near Circle Office, and he told me that he was going to Circle Office to submit the NOC form. I saw Raju Ghosh submitting the NOC form to one Arun Das, who is an employee of Karimganj Circle Office. I do not know any further regarding the incident. So these are the statements and the charge sheet investigation report I have annexed along with this petition, Lordship. And on what basis his name was charge sheeted? He is a practicing advocate of that bar, Lordship. It is a prestige issue to him also, Lordship. And there is no connection. All are like civil in nature. They executed the sale deed only. So whether any implication in respect to the petitioner, my learned friend may point it out. He has the case diary. And then I will reply with some decisions. Whether any whisper of allegation against the petitioner.
Scan copy received, my lord. But it is a case of conspiracy, Lordship. Lordship may kindly come to my lord the FIR as page 24, my lord. I am not reading the entire, my lord. Only the relevant portion of the FIR. So 24 of the criminal petition, my lord. This FIR was lodged by the employee of the circle officer of Karimganj, my lord, circle office. Page 24, my lord. I am not reading the entire, my lord. The middle portion. আমরা বিশ্বস্ত সূত্রে জানতে পারি যে বিগত 20/9/2021 ইংরাজী তারিখে 251 মাননীয় করিমগঞ্জ জিলাধিপতির মহোদয়ের অফিস থেকে এক খণ্ড অনুমতিপত্র বাহির হয়। মানে দিস ইজ দ্য এনওসি, my lord, issued from the office, my lord. কিন্তু এই অনুমতিপত্র বাহির হওয়ার জন্য মাননীয় সার্কেল অফিস হইতে কোনো ধরনের প্রতিবেদন আমরা দিয়ে নাই। They have not issued any report, my lord, but without their report, my lord, a NOC was issued from their office. পরে জানিতে পারি যে বিগত 11/11/2020 ইংরাজী তারিখে আমাদের সহি নকল করে কোনো অজ্ঞাত ব্যক্তি আমাদের কাজ তাহার নিজের হস্তে সম্পাদন করে তদন্ত প্রতিবেদন জমা দিয়েছে। পরবর্তীকালে রিভেরিফিকেশনের সময় একই প্রতিবেদনে বিগত 4/8/2021 তারিখ ইংরাজী তারিখে আবার 1 নং দরখাস্তকারী সহি জালিয়াতি করে পুনর্বার পূর্বের মতো তদন্ত প্রতিবেদন জমা করিয়াছে। তৎকালীন সময়ে 2 নং দরখাস্তকারী অবসরপত্র গ্রহণ করায় তৎকালীন এসকে তদন্ত প্রতিবেদন সহি করেন। Now, this case was registered under section 120B, my lord, 420, 468, 471 IPC, my lord. Now, my lord, after investigation, lordship, search sheet was submitted. My lord, the search sheet, lordship, the vernacular lordship will find at page 36 and 37, my lord. My lord may directly come to my lord page number 37, my lord. Page number 37, my lord, middle portion. তদন্তকালীনত গুচৰীয়া পক্ষ আৰু সন্দেহযুক্ত ব্যক্তিগণৰ হস্তাক্ষৰ সংগ্ৰহ কৰি এফএছএললৈ প্ৰেৰণ কৰা হয় আৰু পৰীক্ষাত শ্ৰী মিহিৰ কান্তি চন্দৰ হাতৰ আখৰ সৈতে জালি কৰা নথি আখৰ একোজন ব্যক্তি অৰ্থাৎ মিহিৰ কান্তি চন্দৰ বুলি প্ৰতিবেদন পোৱাত শ্ৰী মিহিৰ কান্তি চন্দা চন অফ চয়েন্সক গ্ৰেপ্তাৰ কৰি ন্যায়িক জিম্মালৈ প্ৰেৰণ কৰা হয়। তদন্তত দেখা যায় যে শ্ৰী ৰাজু ঘোষ, অধিবক্তা অৰিজিৎ দাসগুপ্তা, অৰুণ কুমাৰ দাস ওৰফে মান্না, মিহিৰ কান্তি দাস সকলোৱে এক চক্ৰান্ত কৰি নথিপত্ৰ জালিয়াতি কৰে আৰু চৰকাৰী কাৰ্যালয়ৰ নথিপত্ৰ সংগ্ৰহ কৰে আৰু মাটি ক্ৰয় কৰে। সেয়েহে পদকীয়া ৰাজু ঘোষ, অধিবক্তা অৰিজিৎ দাসগুপ্ত, অৰুণ কুমাৰ দাস ওৰফে মান্না, মিহিৰ কান্তি দাসৰ বিৰুদ্ধে আণ্ডাৰ ছেকশ্যন 120B, 420, 468, 471 IPC সুপ্ৰতিষ্ঠিত হয়। সেয়েহে তেওঁলোকক আণ্ডাৰ ছেকশ্যন 24 IPC ধাৰাত বিচাৰৰ সন্মুখীন হ'বৰ বাবে মহামান্য আদালতত অভিযোগ পত্ৰ দাখিল কৰিলোঁ। My lord, after investigation, my lord, after recording the statement of the witnesses vis-a-vis the, my lord, FSL report of the, my lord, specimen signature, and this search sheet was submitted, my lord. Now they have come for quashing, my lord. For the quashing, my lord, there has to be absolutely no material, lordship. Now the FIR, lordship, it disclosed the offense commission of cognizable offense, my lord. And when the FIR disclosed commission of cognizable offense, lordship, it is not a case of, my lord, quashing, my lord. It is from 1992 onwards, Bhajanland onwards, my lord, it is very much clear, lordship. If the FIR disclosed the commission of cognizable offense, my lord, my lord, FIR cannot be quashed, my lord. And there are other Supreme Court decisions also, my lord, from Niharika also is there, my lord, where, my lord, Supreme Court is very strict, my lord, regarding quashing of the FIR, my lord, if there is prima facie material, my lord. In this case, my lord, it's a case of conspiracy, my lord. There may not be any signature of the advocate, my lord, that he has forged it, my lord. But whether conspiracy is there or not, my lord, that has to be, my lord, looked into at a time of trial, my lord. So, my lord, considering the materials on record, my lord, this is not a case of quashing, my lord. The criminal petition may be dismissed. He is appearing for the informant, my lord.
I'm for the informant, my lord. No, my lord, as soon as this thing has come to my knowledge, my lord, I have filed the FIR. Because the allegation is that my signature was false, my lord. I am a Kanungo, my lord, working in the circle office, and thereafter, my lord, from the investigation, which is the translated part, page 29, my lord, as my land senior has read, that at the house of the advocate, my lord, some 2 lakhs rupees was paid to one Arun. May I point out, my lord, page 29. Page 29, my lord, of the criminal petition. May I read the paragraph, my lord? The second paragraph. During investigation, the informant and witness were interrogated, documents were collected and seized and got it seen by the Honorable Court. Statements of witness were recorded before the Honorable Court. Raju Ghosh, son of Mihir Kanti Chando, involved in the case, was arrested and produced before the court. In the statement of accused Raju Ghosh, son of late Naresh Chandra Ghosh of Bari Road, it is reflected that in the residence of advocate Arijit Dasgupta, son of late Ashish Bhushan Dasgupta of Park such and such Assam, the official work was done. And he paid rupees 2 lakh to Arun Kumar Das alias Manna to perform the official work. So there, my lord, the role of advocate has come, and because of the charge sheet has been filed, my lord. And it is not, so my lord, going by the FIR and the investigation, and if we go by the Bhajanlal's, my lord, principles for quashing of point 3, may I read, my lord, where the uncontroverted allegation made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offence and make out a case against the accused. So, my lord, here we cannot say that no offence has been called out during investigation. So, perhaps this, my lord, 482 is at this stage may be premature, my lord, or may not be maintainable.
Yeah,
because during investigation, my lord, the role of the advocate was clearly found out by the IO, and thereafter, my lord, charge sheet was filed. This principles is also quoted in the petition itself, my lord. Page 12.
Para 17.
But who paid this 2 lakhs?
As part that, may I read again? It is reflected that in the residence of Advocate Sri Arijit Dasgupta of son of late Ashish Bhushan Dasgupta, Assam, the official work was done, and he paid rupees 2 lakh to Arun Kumar Das, alias Manna, to perform the official work. So that is very specific, manner. He paid. The case of conspiracy, manner, is very much clear, leading by the investigation, manner, going by the
This
investigation.
is he paid means Raju Ghosh paid, Lordship, not petitioner, Lordship. It is clearly stated that I will clarify, Lordship. Let him think. the line started with in the statement of Raju Ghosh. The line started with that in the statement of accused Raju Ghosh, son of so-and-so, it is reflected that in the residence of Advocate Arijit Dasgupta of so-and-so Assam, the official work was done and he paid. So it is paid by Raju Ghosh, Lordship, not Arijit Dasgupta. He is an advocate, why he should pay the amount? It will be by the purchaser. So he paid rupees 2 lakhs to Arun Kumar Das. And statement of Raju Ghosh, I am reading from page 46, that is the original in vernacular. তেওঁ খুদাত কয় যে মোৰ নাম ঠিকনা আৰু বয়স উপৰোক্ত মতে সত্য হয় মই পাচলি হোলসেল ব্যৱসায় কৰোঁ মোৰ ঘৰলৈ এদিন শ্ৰী পূৰ্ণেন্দু কুমাৰ সাহা আহে আৰু তেওঁ মাটি এডোখৰ বিক্ৰী কৰিম বুলি মত প্ৰকাশ কৰে কিন্তু মাটিৰ দাম দৰত নিমিলাৰ কাৰণে মাটি কিনা নহল পাছত সেই মাটিৰ মূল্য কম বুলি কোৱাত মই কিনিবৰ বাবে মান্তি হওঁ মাটি দুখৰৰ দাম প্ৰথমে 1 কোটি 30 লাখ বুলি কৈছিল পাছত 1 কোটি 16 লাখত ঠিক হয় বায়না হোৱাৰ সময়ত 16 লাখ টকাত মাটিৰ দাম দেখুৱা হৈছে মই মোৰ উকিল অৰিজিত দাসগুপ্তাৰ লগত কথা পাতি শ্ৰী অসীম কুমাৰ দেক লিখা মেলা কৰি দিব কওঁ আৰু পূৰ্ণেন্দু কুমাৰ সাহায়ো সন্মতি দিয়ে বায়নাৰ দিনা 5 লক্ষ টকা দিয়া হয় আৰু পাছত 11 লক্ষ কিন্তু উক্ত টকা কাগজে পত্ৰহে লিখা হয় বাকি টকা কাগজত লিখা হয় মই পূৰ্ণেন্দু কুমাৰ সাহাক দিবলগীয়া 1 কোটি Chandu Chik 16 lakh. Some other persons he paid the amount, Lordship. মোক পূৰ্ণেন্দুৱে কয় যে তেওঁলোকৰ ওচৰত তেওঁৰ ধাৰ দিবলগীয়া আছে so as per Purnendu's request he paid some of the amounts to different persons they are the borrower of Purnendu the owner of the land Manna উৰফে অৰুণ দাসকো পূৰ্ণেন্দুক দিবলগীয়া টকাৰে 2 লক্ষ টকা দিও So he paid the amount from the consideration amount. How the advocate is associated with this? My learned friend is correct. There is prima facie material, then charge sheet in his name, Lordship. Where is that prima facie material in the charge sheet? Where is that prima facie material in the statement of the accused buyer purchaser? Nowhere, Lordship. There is nothing about the petitioner, Lordship. Let them show a single line about him, Lordship, whether the advocate paid that amount. We are also advocate, Lordship. We know what we are doing, Lordship. If someone tomorrow comes and said that she take 1 crore from me, whether it is believable unless until there is a proof, Lordship. So how an advocate can be associated with the preparation of NOC? How the advocate will go to the deceased office and took the signature of those persons, Lordship. It is the official persons who have fraudulently prepared the NOC, even if it is presumed that it is a true story, Lordship. Then the official persons have prepared. I am not concerned. So I am praying to quashing the charge sheet or the entire proceeding in respect to the Lordship petitioner only. And in fact that Arun Kumar Das already died, the seller already died. 2 persons already died, Lordship. The main persons already died and now I am suffering. I am practicing in that district, Lordship. And Lordship, that is regarding Bhajan Lal, I have already quoted that in my para 16, page 11 and 12. And I am taking the ground 3, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offence and make out a case against the accused. So if there is no prima facie material against the petitioner, where is the question of going for trial? Where I am practicing, there I have to go for trial for a offence. So in view of guideline number 3 set above, it is a fit case for quashing, and as such for the end of justice, the impugned charge sheet, insofar it relates to the petitioner, may be quashed. And if it is in respect to the charge sheet of the petitioner, I am relying on this judgment, Lordship. There is no bar to quash the in part charge sheet, Lordship. I am relying that page 20, Lordship, para 24. It started from para 23, page 7. Page 24, para 24 is the finding, Lordship. I am not taking so much of time as others are also waiting, Lordship. In view of the above facts, we find that the charges against the appellant under section 3(1)(r) of the Act are not made out. Consequently, the charge sheet to that extent is quashed. The appeal is disposed of in the above term. So, in part also, the charge sheet can be quashed, Lordship. In this case, in respect to that offence, charge sheet was quashed, and I am praying that in respect to the petitioner, the charge sheet and the entire proceeding may be quashed, Lordship. And the fault of the advocate, Lordship. That is, I am relaying the next citation, 2012 citation, Lordship. There the opinion given by the advocate, Lordship, for the opinion given by the advocate, he was, Lordship, charge sheet was filed against him. There in para 30, Lordship, page 531. Para 30, last paragraph. Therefore, the liability against an opining advocate arises only when the lawyer was an active participant in a plan to defraud the bank. In the given case, there is no evidence to prove that A6 was abetting or aiding the original conspirators. However, it is beyond doubt that a lawyer owes an unremitting loyalty to the interest of the client, and it is the lawyer's responsibility to act in a manner that would best advance the interest of the client. Merely because his opinion may not be acceptable, he cannot be mulcted with the criminal prosecution, particularly in the absence of tangible evidence that he associated with other conspirators. At the most, he may be liable for gross negligence or professional misconduct. If it is established by acceptable evidence and cannot be charged for the offence under section 420 and 109 IPC, along with other conspirators without proper and acceptable link between them. It is further made clear that if there is a link or evidence to connect him with the other conspirators for causing loss to the institution, undoubtedly the prosecuting authorities are entitled to proceed under criminal prosecution. Such tangible materials are lacking in the case of the respondent herein. In the light of the above discussion and after analyzing all the materials, we are satisfied that there is no prima facie case for proceeding in respect of the charges alleged in so far as respondent herein is concerned. We agree with the conclusion of the High Court in quashing the criminal proceedings and reject the stand taken by CBI. So, Lordship, in respect to the conduct of the advocate, that his Lordship, the entire claim, criminal offence was quashed, Lordship, under 482. And the 482 powers, Lordship, that is there are some steps given in this decision by the Honorable Supreme Court, Lordship, relying on the judgment of Lordship, that is Rajiv Thapar and others. Lordship will find in page 8, Lordship. Second but last, Lordship. Page para 30. Para 30. Based on the factors canvassed in the foregoing paragraphs, we would delineate the following steps to determine the veracity of a prayer for quashment raised by an accused by invoking the power vested in the High Court under section 482 CRPC. Step 1. Whether the material relied upon by the accused is sound, reasonable and indubitable, that is, the material is of sterling and impeachable quality. thereafter, Lordship, 5 steps were given, 30.1 to 30.5, Lordship. So these are the steps. If the answers to all the steps in the affirmative, the judicial conscience of the High Court should persuade it to quash such criminal proceedings in exercise of power vested in it under Section 482 CRPC. Such exercise of power, besides doing justice to the accused, would save precious court time which would otherwise be wasted in holding such a trial, as well as proceedings arising therefrom, especially when it is clear that the same would not conclude in the conviction of the accused. So, Lordship, I am relying on this judgment. Your Lordship may consider the case of the petitioner for quashing in respect to the petitioner only, Lordship, as there is no prima facie material against him, Lordship. This is a complete case of abuse of the process of the law, Lordship. So my humble prayer before your Lordship to quash the entire proceeding. It was subsequently numbered as PRC 969/2023, Lordship. That I have not annexed along with the petition. Only GR case I have mentioned, Lordship.
Yes. My lord, my humble submission is that based on the materials, my lord, and detailed investigation charge sheet has been laid, and he has been laid in accused, so it is not a fit case, my lord, where this court may exercise the power of 482.
In fact, the power of 482 upon High Court is wide enough, Lordship. And in these situations, it is required to stop this proceedings, Lordship. Otherwise, the person will be humiliated in front of his own workplace, Lordship. Obliged, Lordship. Lordship is making it CAP. Obliged.
May it please your Lordship. Lordship, my senior he has some personal difficulties today. Can I matter be fixed after vacation, Lordship?
Who is the chief?
T.S. Hazarika, Lordship.
One. Bora, what number?
Lordship.
Don't share in the name section and other state.
Immediate after vacation. Lordship, interim order passed earlier, may continue. After vacation. Obliged.
Please, Your Lordship, in his case, my Lord, the petitioner has approached before this normal court. Challenging an order, impugn order, my Lord, passed by the
the office note registered one Mr. S. Hawk and Mr. M. Islam has already appeared for the full response. And their names have also been
reflected in the policy.
It seems to be absent. So you are directed to pay permanent alimony of Rs. 1 lakh.
Yes, my Lord. Well, I do not have any income, my Lord. That is why the petitioner has approached before this honorable court, selling, my Lord.
Matter is, I mean, was it a divorce with them?
Yes, my Lord. My Lord, my humble submission before this honorable court, as the opposite party has not appeared, though their names were reflected in the position, my Lord. I pray for interim relief, my Lord, just to state the operation of the impugn order, my Lord. As per the last order, my Lord, there is an observation.
Permanent alimony, I am surprised. So now you are seeking for interim. Your Honor?
W. Rahman.
From office. What? That one S. Hawk and Mr. M. Islam. And their names could be reflected for one. No one. Take it after no, interim cannot be passed at this stage. So, you want any fixed date or
after the reopening, my Lord?
After reopening, immediately after reopening?
After reopening, the case may be fixed, my Lord. In the meantime, my Lord.
You want any date fixed?
My Lord, interim.
No interim. 1 lakh is only paid.
Sir.
Will listed on 30th of July 37. See, interim at this stage, interim is not.
Lord, after the service of notice, my Lord, there was an observation in the previous order, my Lord. After the service of notice, my Lord, the first order, my Lord, of this.
What kind of interim? What kind
Well,
of
just to stay the operation of the impugn order.
May it please, Your Lordship. My Lord, this is a petition under section 482 challenging the act of attachment made by the IO. Attachment under Assam Cattle Preservation Act.
Lordship, in this matter, LCR received Lordship, but Lordship, I need some time to go through the LCR. So I was not able to go to entire record. Otherwise, he may submit his part, Lordship.
Part. I won't take part.
Yes.
Because our bench
Yes,
is
Lordship,
there,
yes,
you
Lordship.
cannot say. It is there.
Yeah.
Otherwise, it is the attachment order against the cattle preservation.
Assam Cattle Preservation Act. Attachment of properties. Attachment of property which was made by the investigating officer under section 11 of the Assam Cattle Preservation Act.
11.5 or 11?
11.11.
11.11.
11.11. Just limited issue, my Lord, it will take less.
Let him be prepared. Also, some about. Now, this is the scan copy only. Can be
Scan copy
can
only.
be there no issue.
Yes.
Let it be on immediately on the
If I,
vacation that is
if I
15.
complete my part, my Lord, then he can.
No. The question is that he wants some more time. I don't want to keep it part. That is my. Otherwise, your prayer is limited and the entire matter is also limited. Maybe.
It won't take much time.
Yes, question.
Then Lordship, maybe the last time, in the meantime, I will try to go through.
Already about to be 4.
Yes,
So,
Lordship. Maybe any date in my line. Say that part is
third party is already under attachment.
Yes. Attachment and the only issue is that before attaching my property, no notice was served upon me, for which I could not appear before the IO and participate. That is the only issue. And IO has admittedly in his report submitted before the magistrate, he has admitted that he had not served any notice upon the petitioner. That is admitted part.
So is there any order passed by the magistrate?
No. But the act...
You have directly come against the order by the...
Against that, I preferred an appeal.
Okay.
Appeal was dismissed, saying that the act was simply irregular and it was not appealable. But it was, since it was made under section 11, so definitely we must have a remedy before the session judge under section 12. So that was overlooked by the learned court below.
Oh, what?
Only limited is no notice was issued. And that is admitted. It's there in the record.
Yes, so you want to say the record or what?
Actually, without going through that.
Also matters of 79 matters.
If I finish my part, then he can go through the record, and at the end of the day, if time permits, then
Here today, together, not part.
bring up your lordship.
Yes, for sure. His question is a bit limited one that
Whether the
the
not-
attachment order was passed by the IO under 11.
Yes.
I think that was one.
Yes. And at best, your lordship.
That was overlooked by the...
And at best, your lordship can always remand the matter back to the IO with a direction that I can participate in the inquiry. That can be done. So our prayer may be limited to that extent. So up to your lordship. If your lordship wants to
Like
hear.
Mr. Butcher, it will by 10 minutes. Can,
Lord. Lord.
but after 4:30,
Yes, yes, Lord.
I think I have to go today by 8. So there are also
Yes, Lord.
otherwise I've been property is already under attachment.
Yes. Up to you.
Yes, Butcher.
Actually, I didn't get time to go to the LCR.
Yes, you are also busy about it.
Lots of, and even some matters I have gone through, but today is
Some
not
of our the public prosecutors are not available. Or
not available due to some difficulties.
Then after vacation, immediately after vacation.
That is
Other-
that they are
Yes,
facing some
yes.
trouble because
Yes,
the courts are taking the criminal matters, but the numbers of the it will be on 15 then. That is not happening.
It's very difficult to get dates actually. And this matter has been pending since last year. So
Since last year.
yes.
Oh yes, yes.
23
2023 matter, na?
So after vacation.
Actually, today one mention has been made by MS Godrej.
Right.
Her case also most probably it was
Right.
that for 6 times and then it repeat. So he made a mention in the morning hour, so we can do it compliment
Right.
at the. So similar kind of mention
Yes.
maybe made on 15. So immediately our reopening day is 15 it on 15. Because CD is with us, no issue of any
My lord.
calling for the case there.
No.
So we
Uh,
can pick
the record is there.
Yes,
the records
record
of the
is record.
record. Yes.
So there's no
No.
problem. So it will be fixed up. We'll stick it up.
Highly obliged.
May it please your ladyship. LCR has been received. The instant petition challenges the domestic violence proceedings pending before the Chief Judicial Magistrate First Class Kamrup.
Pending to Chief Judicial.
Yes.
Yes, yeah. Yes.
Your Ladyship would like to hear it today or on a hearing day? Because
How much time will it take? It will depend on that.
May it please, Your Lordship, because this matter is very sensitive and urgent, Your Lordship.
Sensitive and urgent?
Yes, Your Lordship. Because since the month of June 2023, the husband is, that is the present petitioner, is not paying anything to the wife as well as his kids. The aggrieved has 2 kids, Your Lordship, and they are maybe 6 years or 7 years, Your Lordship. Now they are student of schools. Not a single penny was paid regarding their education expenses and nothing. So, Your Lordship, I am humbly praying before this Honorable Court to take up this matter today, Your Lordship, because LCR has received Your Lordship. And the Honorable JMFC did not take up this matter, Your Lordship, as this matter is pending before this Honorable Court.
Right? Petitioned by court. Your part, you heard, how much time will it take? 15 days?
It will take some time.
Actually, there is lots of separation in this matter, Your Lordship. Before earlier, they have opposed the Honorable Supreme
Otherwise,
Court.
it will remain as a partner. Partner, what is the problem with partner? In fact, I'm saying, partner, if remain partner, I don't know my next bench will be when and where. Because roster will be changed again.
Yes, yes.
So I maybe there are Ronachal or Kohima, I don't know.
Yes.
So that's why partner is a bit difficult. Because it may not be. Suppose next week it cannot be fixed.
Yes,
next
yes.
week
Yes.
and anyhow it cannot be fixed. So that definitely will come after vacation. Vacation
If
also,
Your
I don't know
Lordship
if it's
allow
partner
me,
then. Yes.
if Your Lordship allow me, I just want to bring some important document.
No, documents first. He will submit first.
Yes.
Then
yes.
so in that case, if we are going to hear the matter, but it will remain as a partner. Next partner, I don't know when it will come. That is the main.
And
So start. It will remain as a partner.
May it please Your Ladyship. The instant 482 petition challenges the initiation of the Miss DV case, hearing number 148 of 23, pending before the Court of Chief Judicial Magistrate First Class. A false and concocted story has been cooked up by the respondent number 2, who is the wife of the petitioner, by way of the Section 12 petition. She has in fact hurled abuses against the petitioner, making false allegations therein, and a case of physical abuse, mental abuse, and emotional abuse has been made out therein, and took the elder son Meghavardhan to Tirupati Balaji temple for offering hair to Lord Balaji. After shifting to a new accommodation located near her brother's place of stay, the respondent too started feeling uneasy, having lot of nightmares, bad dreams, hearing all odd sounds, which was accompanied by other paranormal activities, and therefore pressurized the petitioner to get a new accommodation for them. Then para 17, that sometime in February 2014, the petitioner's worry for the respondent two's health shifted to Natyapalam, which is at a distance of 5 kilometers from the previous house, and during that time frame, the respondent two's brother resigned from his job, and both respondent two and her brother shifted back to Samtanagar. So it is a case where he has been maliciously prosecuted and brought into the picture when it is not that he has not been maintaining a healthy relationship with his family members and in-laws, and also with his wife and 2 sons. Rather, by registration of this case has made him separate from his 2 sons, who also need their father, and they were doing well when they were studying in South India and doing quite well in their school. But they had to, their education there had to halt, and they came back to Guwahati with their mother. So now, that's my respectful submission. I'll then reply to what my learned.
Remain as the partner.
But I am a humble prayer, Your Lordship, immediately after vacation, Your Lordship, because as my learned friend is stating that he is continuously paying maintenance, but he has filed a certain liabilities where he himself stated since the month of May-June 2023 he has not paying any single penny to his wife. The reason he has disclosed that my wife stopped talking to me. That's why he is not paying anything. So the moral obligation of a husband as a father is to pay maintenance to the wife as well as his kids, because as he stated, his kids, he is old. But he did not follow any court orders, he did not follow his moral obligation also. Then, Your Lordship, I will not take up Your Lordship time. If Your Lordship permit, then 2 minutes, only one time I will take up Your Lordship. The certain liabilities which they have filed, it already come in the LCR has already received, where he has stated that my wife is not employed, and
one timing is another, one timing is there.
Pardon, Your Lordship.
One more timing is there. So it will be remain part.
Immediately after vacation, Your Lordship. A date may, if Your Lordship, a date may be fixed, Your Lordship.
After vacation, so I'll fix, but my bench may not be here. And it will see.
Oh.
It's good part, but after vacation will be. But if I'll be here, then it's okay. Then it will be set.
Obliged, highly obliged.
My lord, one bail was kept, Lordship, for on medical ground, Lordship. That item 25, Lordship, for the medical report, Lordship.
Other matter will be. No matter.
No, sir, I'm not paying for
Next week, no date either.
But Your Lordship has to grant the bill on medical ground that he is positively accepted to carry
No medical ground. Anyway, from Monday to Wednesday, my bench will be only up to 3:30. So, as a whole, we don't get time. I don't know if she talked to his.
I'm sorry, Lordship, for disturbing you, Lordship. That item 25, Lordship, pure on medical ground, Lordship. So up-to-date status was called for, Lordship.
Medical report, we have already submitted on the last occasion, Lordship. Lordship has called from my lord.
It's not,
But there is clear, my lord. Today we have received this report, my lord. Lordship, other part has this same part, little bit they have added, my lord.
So otherwise, as per your submission, must really be suffering from some kind of.
No, he is from H,
and he
Lordship.
is a patient of HIV.
HIV, Lordship, that medical documents I have already annexed in the petition. Father said he got some infection and Lordship, and his legs has been swollen and he is in not stable condition, Lordship. That is my prayer, Lordship. 37 days and not from his conscious position, Lordship. That is the part, Lordship, and the recovery was 28.160 gram, Lordship. And in Lordship, local person, he is from that locality only, nearby police station, Lordship.
It's an intermediate quantity, Lordship. As far as my lord, the materials are concerned, there are material, Lordship. And my lord, today is 38 days, my lord. 38. If Lordship, my lord, grants my lord only on a considered the medical report.
Otherwise, he is a better.
No, not conscious position, Lordship. Nothing mentioned in the
That is
forwarding.
not clear,
like
my lord,
earlier.
whether he is a peddler or not, my lord.
Nothing mentioned. He
28 gram, 28.160 gram recovered, my lord.
28
28. It's intermediate quantity, my lord.
He had a dam, Lordship. From dam it was recovered. So many people comes and go, Lordship. Somebody might have kept their Lordship. We have got no previous record also, Lordship.
The dam belongs to you only.
That is why I'm behind the bar.
He has a dam, in fact.
Dam, my
Where
lord?
it goes, the contraband were recovered.
From the dam, my lord.
From the dam.
From the dam, my lord, and it is as per the CJRD lordship. It is seized from my lord Samsul Haq and Monish Kanti, both from both the person, my lord. There are two accused persons, my lord.
He is Samsul.
He is Samsul Haq, my lord.
That means he was contributing the things from his dam.
My lord, so probably, my lord.
Lordship, kindly see his address, Lordship, from the same locality nearby the police station, Lordship. At any point of time, Lordship, I will cooperate, Lordship, and no previous record, nothing, Lordship.
Materials are there, my lord, that is good.
Materials, when I also admit that is recovered from my dam, Lordship. It is not, I am not denying to that fact, Lordship. Only on purely on medical card regarding the medical, Lordship, already 38 days, Lordship. Kindly any condition, Lordship, residing nearby the police station, which are local person, kindly look at the cost title, Lordship, his address.
In fact, city we have visited the city also.
My lord.
The last occasion we have visited the city.
Yes, last occasion we received the city along with a medical report, my lord, but lordship has
was
for
not
some
so
more,
clear, yes.
my lord, clear picture, my lord. That is why, my lord, today we have again obtained the, my lord, medical report, my lord.
Last medical report, see, but some, but medical, but other medical report also from the as the earlier report was not with as and what kind of treatment provided and whether it not if the or obtain another medical report when it's when that presently and it can from apart from that, there's no complaint of having uric uric acid and other and for medical for he had some kind of test and apart from his X-ray was also done on ankle rhythm and both of get complete right for which is as advised by doctors of Tipu Medical College. That's not but he is not even a position to stand up and to walk and stand up. And as we did that, he is also teacher on part of the subject learned the history not but it subject is different. That's here. But it's them and but since when?
It's with a Deepu Karbiala.
No, since when he is
Custody lordship on 15/5. 38 days.
He was not some neck. Yeah. And how he got it and being president of the year and he being a of the year round of
Especially the Deepu Karbiala. Much obliged, your lord. Much obliged. Much.
May it please your lordship. Lordship, in item number 54, lordship, we have taken steps twice, lordships. Till now, lordship, the notice has not been received by the respondent lordship. Lordship, an order may be passed that on the next date, our interim prayer may be considered, lordship, because they are trying to postpone the matter in this manner, lordship. After taking steps twice, lordship.
We'll try to fix it immediately after vacation because we don't have. We cannot. Fix it next week. Not at all possible next week. So definitely it will be after vacation. Made the submission or that day also. In the meantime, the any process being done also. Let us see if the process is there.
Yes.
It's okay.
Yes.
Otherwise, you have taken steps.
Yes, lordship.
Already most probably the note will be raised also.
Yes,
so
we've taken steps twice, lordship.
Okay,
yes.
we'll check. That's immediately after. Try to open.
Yes.
My lord, item number 59, petitioner wanted to withdraw the criminal division.
Your Honor, already the payment has been made. Payment has been made by by us from the petitioner's side.
59.
59.
It's a hearing matter.
It's a hearing matter.
Yes, there was an amicable settlement. In the IA matter, the IA matter was disposed of on 14/5. So, Your Honor, we have already paid the amount. There was a check amount of 1,10,000 and we have paid it in 2 installments to the...
So, in the petition, you are the accused person?
Yes, I was.
So, are you accused there?
Yes, ma'am. They have already paid and we have given the money receipt to them as well. 40.
Now, see, this photo from your side with the verbal submission. But suppose subsequently you say that to enter money is supposed not paid and all. So you may raise the question for the tribunal. So why don't you submit a simple affidavit?
Memorandum.
Yeah, we may list it on the next day because it will be a matter of 12. So let it be listed on 27/6 this week. Then in that case, I just need an affidavit from your side so that the matter has already been settled. Otherwise, there will be scope for again a better So we are fixing it on 27C. Try to
27.
file the affidavit.
Yes.
My lord.
It will be picked up with the hearing column itself. Will dispose of the matter.
Yes.
Obliged.
Obliged.